May I please, Your Lordship? With the consent of the other side, Your Lordship, I beg to mention item number 54, motion matter, Your Lordship. May I pray for taking up this matter on Monday, Your Lordship? I am to receive some instruction, Your Lordship, there.
44,
54, Your Lordship.
54.
Monday, Your Lordship. Then eviction notice we have put to challenge, Your Lordship.
Item 54, the request made by the council for the petitioner stands deferred to be listed on
Monday, Your Lordship.
second.
Lordship.
I have a prayer for listing of a motion matter, my lord, on Monday, my lord.
New matter,
New matter.
I have similar prayer for motion matter Monday, my lord.
Monday.
Monday, my lord.
All right.
Much obliged.
May I please, Your Lordship? Lordship, I'm praying for listing of a writ petition in the admission column, Lordship, because this matter pertains to a cremation ground, Lordship, and that has been stayed, Lordship. Any day next week, Lordship.
9th,
May I please, Your Lordship, with the consent of the other side, I beg to mention item number 34. Lordship, we need further time to file our affidavit in this matter.
34.
34, Lordship.
Lordship, the interim order may be extended, Lordship, and for the petitioner, Lordship, instead.
34 stands deferred to be listed after 2 weeks.
Lordship, 4 weeks.
4 weeks
Lordship.
is prayed for on behalf of the respondent council. Interim orders passed earlier will continue. M.S.R. Borua appears to the writ petition.
Hi, Lordship.
May I please, Your Lordship? Lordship, praying for listing of a matter for today, Your Lordship.
Okay.
The urgency that once some election has been conducted, Your Lordship, of Assam High School Teachers Association, Your Lordship. That election has been conducted, Your Lordship, by violating Niyamavali and some
By violating
regulations, Your Lordship, of the association and by electoral bylaws, Your Lordship. Now, Your Lordship, the newly elected committee, Your Lordship, is going to hold the executive meeting on Monday, Your Lordship.
So, who are you?
I'm the General Secretary for the post of General Secretary, Your Lordship.
You were
Pending
not elected.
I have not been elected, Your Lordship.
So you have to. There must be some provision for challenging the election.
Provision is there, Your Lordship. Within 15 days, Your Lordship, we had to file a representation before the electoral officer, Your Lordship. So election officer, we have did it, Your Lordship. We did it, Your Lordship.
Oh.
We have done it, but they never turned up, Your Lordship. For that reason, Your Lordship.
Have it on Monday.
Monday, because, Your Lordship, Monday is going to be the executive meeting for
Let
with
it
due
be,
respect, Your
let
Lordship.
it be, we'll see. When was the election held?
Election 13 December, Your Lordship.
Then why are you coming today?
Your Lordship, we paid before the electoral.
That's all right, but why this steering hurry of doing it unlisted today for a meeting to be held on Monday?
Yesterday also I mentioned, Your Lordship, but
You did not mention before this court.
no, because before 18, they are
Oh.
thinking that it was an academic matter, Your Lordship. But after that, I got to know that it was a Bands 5 matters, Your Lordship.
All right, Monday, you bring it on Monday.
May it please, my lord, prayer for listing of an admission matter.
Admission,
Next week.
9th of February.
Oblige.
May I please, Your Lordship, for motion matter, the list, it may be listed on Monday, Lordship.
Why? Oh,
There's some urgency, new matters, Lordship.
new matter.
Lordship.
When did you file it?
Day before yesterday, Lordship.
What is the subject matter?
Subject matter it is a contract work, Lordship. Contract
All right, Monday.
oblige.
My please, Lordship, in item number 25, I filed one additional affidavit, Lordship. Can you call that
25.
25 also?
You have filed some additional affidavit.
Affidavit in opposition also.
You have filed it.
Yes, also. Today we have filed also.
But then it will come next week. Who's for the other side?
This is insurance company, Lordship, Solamandalam General Insurance Company.
Item 25, counsel for the respondent submits that affidavit has been filed today. Matter be listed on 4th of February. Registry to trace out the affidavit stated to have been filed and list it again on 4th.
Oblige.
I beg to mention item number 27, Lordship.
Hmm.
It is an order column. The matter may kindly be adjourned for today, Lordship. I am for the petitioner, and the cause title hasn't been amended yet, Lordship.
Item 27.
27.
The request of the counsel to the petitioner stands deferred to be listed after 1 week.
Lordship.
Lordship, prayer for listing admission matter.
Admission matter on 11th February.
9 ballots.
11th.
Lordship, I beg to mention item 21 and 22 of today's list, Lordship. Lordship, I have informed the other side, Lordship. Lordship had directed one document to be furnished, Lordship. It's an old document, Lordship. The department is seeking 2 weeks' time to produce that document, Lordship.
Who's for the other side?
Mr. IH Soikia, Lordship, I had informed Mr. IH Soikia,
21, 22
Lordship.
stands deferred to be listed after 2 weeks.
Lordship.
Wait, please, Your Lordship, I beg to mention item 43, my lord, the daily list. I have informed the other side of
43.
43, my lord. After 2 weeks, my lord.
Item 43 on the request of, you are for the respondent,
I am for the petitioner, my lord.
you are for the petitioner. 43, and matter stands deferred to be listed after 2 weeks. It is submitted, consent of the council to the respondents have also been obtained.
Wait, Your Lordship, I beg to mention for listing a matter for admission, Lordship. On 9th, Lordship.
11th,
Lordship, oblige, Your Lordship.
May I please, Your Lordship, it was for instruction, my lord, on the last time.
yes, government, it's for the government.
After some time, right? After some time, Mr. HMI is appearing after.
May it please, Your Lordship. Well, the petitioner and the respondent two are the co-wife of the deceased husband. Right? I have a daughter and the respondent two also have a daughter. Now the question of death certificate of my husband, and that was refused on the ground that the claim has been made by the respondent two who claims to be the first wife. Then Your Lordship has passed the order, my lord, of part of the order, Your Lordship, kindly see. At page 12, bottom, paragraph 8, my lord.
Who is respondent one?
Respondent number 2 is the co-wife, my lord. Oh, 1 is also the wife, second wife.
No, in the writ petition,
Writ petition.
the Hailakandi board,
My lord,
municipal board.
municipal board.
Petitioner was the wife,
Second wife, my lord.
second wife.
Second wife, suppressing the first marriage, marriage.
All right, heard Mr. Tikadari Learned Council to problem. You should notice returnable 4 weeks. Steps on the respondents by registered post within 1 week.
May it please, Your Lordship. With regards to cancellation of GST registration, my lord, I have filed one affidavit also, explains the delay, my lord.
Who's for the respondent?
State GST is there.
Have you enclosed a copy of the order?
Order, last occasion I have given 2 copies, my lord.
Do you have any?
Yes, my, I have, my,
Give us a copy.
yes, my lord.
Or you give us the number at least.
My lord. Well, I just provide my one.
All right, have dispose of. Take it at a copy order depot. Similar order.
Much of the lords.
Yes.
May it please, Your Lordship. My lord, Your Lordship, my query is the order dated 9/1/26.
Any instructions?
No, Lordship, we have not received any instruction. Waiting for some more time.
2 weeks? How much?
Lordship, I will try my level best.
2 weeks.
2 weeks.
Mr. P.K. Roy Chaudhary, Mr. H. Sharma, Learned Council. For the state subjects that further 2 weeks' time is required to complete his instructions. Prayer made is allowed, list again after 2 weeks. We'll fix a date, 27th
27.
of February.
May I please, your lordship? The matter arises out of a workman compensation case, my lord.
In
Yes.
this case also, Lordship, we have received one letter from the Assistant Labor Commissioner. His father is seriously ill in ICU, so he is unable to give the instructions. He praying for some more time, Lordship.
2 weeks.
Lordship, let it be, Lordship, that's because Lordship, there some compensation is claimed by the deceased wife,
Heard
Lordship.
counsel.
Lordship, 2 weeks.
Parties, Mr. H. Sharma, Learned Government Advocate, renews his prayer for further time. List again after all. I will give you 3 weeks. List again after 3 weeks. List this matter again on 6th of March. 6th March.
Bless you.
But for medical emergency, the petitioner sold a plot of land to one Simapal. And accordingly, my lord, applied for sale permission, but the sale permission is yet to be progressed by the circle officer only on the ground of, my lord, transfer of land, my lord, between inter-communities.
Yes, can you get instructions here?
Lordship, no, Lordship, as because this is the first time I think
No,
we,
no, will not issue notice, you get instructions.
Lordship.
Third counsel for parties. The Learned Government Advocate is permitted to complete his instructions as to why the sale permission sought for by the petitioner for sale of the land possessed and owned by him has not been issued by the revenue authorities. List again on 27th of February. Although notices are not issued, extra copies we furnished within the period of 2 working days.
All right.
Yeah, that's. Item 1, Lordship, we have received some instructions. If your Lordships go by this paragraph 10, I think there is some settlement হৈছে নেকি তোমালোকৰ লগত সুধিছিলা client-ক? That 126, the proceeding under section 126 here now it is BNSS. It is non-FR case has already been registered. And it's a dispute between two societies, Lordship. Some settlement, I have found it like that in the paragraph 10, Lordship.
Close কৰি
তাতে পুলিচৰ হেৰিতে আহিছে, তুমি এবাৰ সুধি লোৱা ভাল নেকি?
There appears to be some settlement.
Lordship, it was also revealed that both parties has misunderstanding for a long time. Consequently, the opposite party reached a settlement. Last 3 lines, Lordship, paragraph 10.
Yes.
Let my learned friend get that instruction.
My lord, I do not have that instruction, my lord. Can it be taken up on next week, my lord? Any day.
Matter be deferred to be listed on 11th. As the Learned Government Advocate on instructions is submitted that the dispute in the writ petition is in respect of 2 societies. And as per the instructions received, this misunderstanding has been sorted out and some settlement has been reached by the parties concerned. Counsel for the petitioner submits that he would like to complete his instructions in this respect. List again on 11th. You can take back the.
Lordship.
Your lordship had permitted me to file an affidavit in this matter, lordship. I'm filing the affidavit today. I've served the copy also, lordship. So can it be taken up on Wednesday, lordship?
matter be deferred to be listed on 4th.
Much obliged.
Petitioner to file the affidavit as per report. Mr. B. Chaudhary, the case for the state. Yes.
Much obliged.
Yes.
In this matter, I am the MSME unit. No? I have a relation with the respondent from the last 20 years, my lord. And during the time, my lord, I have done some constructions work, my lord. And since I have not received that money, I am not able to pay that amount. But my lord, my grievances is in respect of that while declaring my account NPA, the respondent bank has not followed the notification dated 17/3/2016. That is in the nature of mandatory. My lord.
Where is the notification?
My lord, I'm coming to it. My lord, kindly come to the page number 14 first, my lord. Page number 14 first.
14.
14, my lord. That is annexure 1. It is showing that I am the MSME unit, my lord. Now, my lord, may kindly come to the page number 35, my lord. The page number 35 is the notification, man. 17 March 2016, my lord. It is issued by the Reserve Bank of India. Page number 35, man. Annexure E. Now, my lord, may kindly come to page number 37. That is the actually eligibility and the identification, my lord. How the process of MSME, a declaration of the MSME account as NPA, man. Clause number 2.1, man. May I read, man? Identification by the banker or the creditor before a loan account of micro, small and medium enterprises turn into the NPA. Bank or the creditor should identify insufficient stress in the account by creating 3 subcategories under the special mention account category as given in the table below. Now, my lord, after table below, my lord, on the basis of the above early warning signals, the branch maintaining the account should consider forwarding the stress account with aggregate loan limit above 10 lakhs. My account total is more than crores. To the committee as referred in the para number 3.3 within 5 working days for a suitable corrective action plan. They have to give me corrective action plan. Man. Forwarding this account to the committee for CAP will be mandatory in cases of the account reported as SMA 2. My lord, now in this reference, my lord, I have also placed one judgment, my lord, on the Supreme Court, sir, that this notification is mandatory, and even if I am not applying for the restructuring of this account, the bank has to give me the restructuring corrective actions plan. Man.
Which bank is it?
My lord?
Which bank? State Bank?
State Bank.
Is there any standing counsel?
No, my lord, I don't think there is any state.
All right.
And even I have applied for the restructuring, they have silent on that matter.
We'll issue notice. You can serve copies by Dusty also if you want.
Yes, ma'am.
Heard Mr.
Madam, in the meantime, I will protection because they have already issued the single house. I have a residence.
Where are the communications?
Yes, my lord. It is in page number 16, my lord. Page number 16, annexure B. That communications is notice they have issued, and the time period of that notice is already expired. In the meantime, I have already given them proposal of restructuring, but they have not replied. Man. That is in page number 14.
And what is the judgment that you are referring to?
Yes, my lord. This is in respect of the Honorable Supreme Court, my lord. In this judgment, in the para number 10, my lord. Page number 4, para number 10, my lord. As stated earlier, the whole controversy in the instant appeal centered around the notification dated 29/5/2015 issued by the central government in exercise of the such and such. The said notification contains the instruction of the framework for revival and the rehabilitation of MSME. The relevant part thereof with regard to the identifications, the same notification, my lord. Thereafter, the RBI also issued notification that is in the para number 11, my lord. The RBI, in order to make the said framework contained in the notification 29/5/2015 compatible with the existing regulatory guidelines on income regulations asset classification and the provisions pertaining to the advances issued to the bank by the Reserve Bank of India had made certain changes in the said framework in consultation with the central government and issued revised framework along with the operations instructions wide communication that is 17/3/2016. That communication I have read before the honorable. Addressed to all the scheduled commercial bank. Now, my lord, this is mandatory, is page number para number 13, my lord. Next page, my lord. In view of the above, it is absolutely clear that the instructions for the framework for revival and the revision such and such in exercise of power such and such, notification dated 17 March 2016 and the master directions, Reserve Bank of India such and such of banking regulation having statutory force are binding to all scheduled commercial banks licensed to operate in India by the Reserve Bank of India as stated as said directions. So this is binding, my lord. They have to give me the corrective action.
We have heard Mr. D. Sharma, then counsel for the petitioner. The petitioner claims to be a MSME enterprise. And for the purposes of undertaking its business, it had applied for a loan from the SBI. Which branch is it?
This, my lord, they have centralized actually system, my lord.
From the SBI Udubari branch. During the process of undertaking its business, petitioner disbursed the amounts, but the recovery was not as per the timelines required to have been made by the petitioner. And as a consequence, there was some default in payments.
Yes, madam.
There was some default in payment of the loan amount. As a consequence, the bank authorities have treated the account to be stressed asset and declared it to be NPA. So, learned counsel for the petitioner submits that in terms of the ministry guidelines dated ministry notification dated 29 May 2015. There is a complete procedure laid down in respect of MSME enterprises who may be identified to be stressed MSME enterprises. Stop. Under the said notification, corrective plans are required to be suggested by the bank or by the creditors, and accordingly steps are to be taken for due correction and restructuring of the MSME so that an opportunity is granted to the MSME to restructure his debts and regularize the dues which are outstanding to the creditor or to the bank. Stop. The learned counsel for the petitioner submits. This notification is mandatory in terms of a judgment of the apex court rendered in MS Pro Nits versus Board of Directors of Canara Bank. Learned counsel, referring to the said judgment, submits that the apex court has held that the procedure laid down in the said notification is mandatory and is required to be scrupulously followed by the bank or by the creditors. Stop. However, in complete violation of the procedures prescribed, the bank authorities have treated the petitioner enterprise to be a stressed asset and has declared it to be an NPA. Being aggrieved, present writ petition has been filed. Better. The learned counsel submits that there is no standing counsel for the SBI. Under such circumstances, let notice issued, returnable 4 weeks, steps on the respondents by registered post. Dusty is also permitted, provided it is routed through the registry of the court. Matter be listed again after the returnable date. Meanwhile, the proceedings undertaken in respect of the present petitioner, declaring it the same to be an NPA, shall remain stayed till the next date fixed.
Deeply.
List again on 6th of March.
Deeply.
Lordship, I am praying for some more time, Lordship. We have not received any instruction.
2 weeks.
Let it be 3 weeks, Lordship.
3 weeks.
Mayor, for a notice, my lord, then affidavit can also be filed. Some issues are there. my
Let me get the instructions as because from the apparently it's a VGR land. So your Lordship is giving them in by way of an interim Lordship stays there, and we have been directed to obtain instructions.
Mr. H. Sharma, learned government advocate, prays for further 3 weeks' time to complete his instructions on the matter.
I think my learned friend is enjoying the interim.
Mr. A.R. Bhuya, on the other, submits that the interim order passed. List again on 27th. 27th.
27th of February, Lordship.
Interim order passed early will continue. The next date of listing.
Online.
In this case also, I'll pray for some more time.
Some more time.
Some more.
Lordship, what has happened in this case, before this notice was issued, the circle officer, with the help of the concerned police station, they have already evicted the petitioner from the suit premises, Lordship. The circle officer, by engaging the concerned Mondal and the Lat Mondal, with the assistance of the concerned IO of the police, the concerned police station, Lordship, they have evicted the petitioner from the concerned land.
Demarcation eviction took place.
Exactly, Lordship. So I will file my additional affidavit to bring on record this aspect of the matter also.
Bring it on record.
Yeah, 2 weeks.
Matter be listed again.
Short date may be given, Lordship, because they are
How much time do you want?
1 week time, Lordship, because they are
1
making
week.
some construction
Matter
also.
be
Lordship.
listed again after 1 week. Enabling the government, learned government council to complete instructions as also counsel for the petitioner to file his affidavit. List on 13th of February. None appears.
After 1 week, man.
Passed over.
Timing.
Passed over. We don't know whether it is timing or the day. Let us see.
Lordship, in this case, some important documents are left to annex your Lordship. Kindly, I will be allowed to file additional affidavit.
Mutation took place. Remedy lies appeal.
The petitioner counsel submits that they would like to bring on record some additional documents by filing an additional affidavit. They pray for 2 weeks' time. Prayer made is allowed. List again after 2 weeks. Mr. N that thus appears for the
2, 3, my lord.
respondents 2 and 3. List again on 20. 20. Yes.
To appeal file.
Lord, I have a limited prayer, my lord. Page 28, representation submitted for enhancement. And that has not been, my lord, disposed till late 1 year.
Circle officer of five.
Lord,
And representation submitted before whom?
my lord,
Circle officer, man.
Circle officer.
Circle officer.
Circle officer is
No,
not
my lord,
involved.
we have also, district magistrate also we submitted, page 27. Both we have
It
submitted.
must be before what, Kala?
Before that, my lord, may I submit?
Because
this project, whatever claim is there, not constructing by NSAIDCL. It is by Ring Road is constructed by NSAI. If at all amount is to be paid or whatever it is we NSAI required, NSAIDCL cannot, that is my first submission is this. NSAI is the proper authority here. NSAIDCL not constructed Ring Road. That is my only.
You want to say that representation should be addressed to NHIDCL?
No, NSAIDCL is made party. But here constructing agency is National Highway Authority of India.
Okay. NHAI.
And HAI.
So they are to be added as parties.
Yes. If
My lord, my
required.
submission is that, my lord. So far, my lord, the enhancement part is concerned, this under the National Highway Act, my lord, arbitrator is already there in terms of section 64. Therefore, the competent authority which they have already designated in page 3, my lord, respond number 1. He has to look into this all aspect, my lord, about enhancement part. That's why, my lord, my limited prayer that the respondent number 1 may be directed to dispose of my representation, and respondent number 2 and 3 may be directed to send this all papers to the concerned authority. That is my prayer, my lord.
Let them get some instructions, at least it is what has happened to this.
Absolutely, my lord. There is no problem.
Then where is your representation?
My representation is, my lord, the page 27 to the district commissioners with the competent authority.
Doesn't say anything.
My lord, we have clearly said, my lord.
Then
understand?
Increase the land amount. What amount you have received?
My lord, amount.
What amount according to you?
My lord, the part of payment we have received, which we have disclosed here, my lord.
Where?
Enhancement part, my lord, I have mentioned, my lord. And document also I have enclosed, my lord.
No, in the representation.
Yes, my lord.
Where
But
is
detailed
not
representation is not there, no doubt, my lord. But they have to consider, my lord, if anything required.
Well, you get instructions, but the problem is, Mr. All right, it's directed to the district commissioner. You get your instructions.
Yes,
what has happened?
With regard to the representation, status of the representation.
Yes, ma'am, absolutely.
DC.
DC Kamrup. Mr. S. Chamaria for the petitioner, Mr. N. for the respondents 2 and 3 will obtain instructions for the status of the representation dated 29/5/2025 stated to have been filed by the petitioners before the district commissioner Kamrup Aminggaon. Although notices are not issued, extra copies will be furnished within 2 working days. Mr. C. Barua for the NHIDCL. Matter be listed on 18th.
Your Lordship, wait, please.
Yes.
I kindly have the communication order at page number 239. Vacation is going tomorrow. And
What are you challenging?
I am challenging the vacation order.
Where is that order?
239, page number 239, annexure 11. And earlier, all the orders in favor of the petitioner by this Honorable High Court. Despite this, this is the.
Who's for NF Railways? Anyone for NF Railways?
Union of India nowadays.
Union.
Union.
Who's for the union? Any CGC?
Your Lordship kindly have
Yes, 239.
239.
CGC. CGC.
239. Your
Yes.
Lordship. In reference to above, as per judgment, Honorable High Court Guwahati against case number so and so, 29th April 2022 has passed the following judgment order. The authority should be entitled for minimum enhancement of 10% every 3 years since 1/11/2010. Further to that, the respondent authority shall also be at liberty to take such steps as envisaged under the law as per its present existing policy in respect to vending units of the petitioner. With the above observations, all its petitions stand disposed of. The interim order passed earlier stand vacated. This was the order, Your Lordship. Your Lordship kindly have. Before this, Your Lordship, when the order was passed, a notice was issued. It is at page number, the order, relevant part of the order, Your Lordship. Page number 178 to 179 of the order dated 29/4/2022.
May I read 178?
178. Yes.
Second para. Consequently, all the communications dated 6 May 2023 impugned in writ petition herein are set aside and quashed. It is in the favor of the petitioners. Before parting with the record, it would be relevant to take note that clause so and so, it is the requirement that upon renewal, the license fee would be increased by minimum 10% and shall be subject to enhancement assessment of actual sales turnover of the unit. By virtue of the communication dated 1/11/2010, petitioners herein were informed of the applicability of the catering policy 2010, and they should pay of their license fee at the existing rate, and subsequent to the fixation of the new license fee, they would have to pay the arrears. Consequently, the petitioners are liable to pay the enhanced fee with effect from 1/11/2010. Taking into consideration that by dint of interim orders, petitioners are still paying license fee at the existing rate fixed in the year 2000, the railway authorities would be at liberty to reassess license fee of the petitioners notionally every 3 years on the basis of actual sales turnover of the unit in the manner to be done in terms of so and so with effect from 1/11/2010 till date of the instant judgment. To claim such. Thereafter, your lordship, kindly have page number 180. Just after that, they have issued the notice. Notice for payment of arrears of license fee at enhanced rate with effect from 1/11/2010 in pursuance of the writ order court, your lordship. The petitioners have deposited the license fee. Kindly have page number 184.
Yes.
184 and 183. Both petitioners have deposited the license fee, what was demanded by the respondents. 711102. It has been deposited in installment with per day interest, 84,000. And second one, your lordship, 21,405. And it has also been deposited per day interest. The order has been complied. Thereafter, your lordship, kindly have all the receipts with effect from 1st January 2022 to 31st January 2026, page number 221. This is the last deposit on 1st January 2026 up to 31st January 2026. They have complied all things. Despite this, your lordship, prior to this communication order, they have not issued a single notice. And not only this, if your lordship may have.
Which communication?
My lord.
Which communication?
The impugned order.
Where is that?
239. Page number 239. 9th January 2026. Direct they passed the, they said closure of wheelbarrow and closure of the South Indian dish. Page number 242. There are the two petitioners.
Yes.
9th January 2026. Even the petitioners, your lordship, they have regularly deposited and they have already made the request at page 237 for the, if your lordship may, annexure number 10, 237, payment of license fee for South Indian dishes stall at NCB station in reference to 18/7/2022. This letter was issued by the respondent earlier in pursuance of the writ order code 6437.
So now they have taken a decision to close it.
To close it without any prior notice.
What prior notice is required?
Because your lordship kindly have earlier
So
order.
this is a notice.
No, this is not a notice. This is the final order. This is not the in the form of notice. Your lordship kindly have the prior order of this Honorable High Court for a moment.
179.
not 179, earlier, how it has been reached here up to this.
Not on that, the liberty is granted by the court to take steps as per the existing rules.
Existing rules, your lordship.
Right, so
Here is
existing
the
rules.
matter, your lordship, the earlier notice was sent for the revision of the license fee, and that was quashed. That, your lordship, kindly have page number
Alright,
140.
we should notice here today.
Your lordship, because tomorrow is the vacation order.
MS so and so. that-
Some, the lady, the petitioner is of 73 years and one is 65 years, and they have single unit. They have no other unit, your lordship. Survival is this,
Learned
and she is issueless lady.
petitioner who runs, what do you run? What?
South Indian dishes counter,
South Indian dishes
counter at platform number 2/3 NCB station,
Platform number 2 and 3?
2/3
2 by 3 at
NCB, New Cooch, Bihar
NCB.
station, railway station.
Hmm.
And wheelbarrow, petitioner number 2 is running wheelbarrow.
And the wheelbarrow run by the petitioner. Stop. The petitioners are aggrieved by the communication dated 9/1/2026, whereby the senior division commercial manager and railway, Alipurduar Junction, has issued this Indian communication directing the petitioners to vacate the wheelbarrow at the NCB station within 31/1/2026. Stop. According to the petitioners, they have been running their outlet for how many years?
Since 2000.
Since the year 2000, and have been paying all the license and the
And the
license fee
agreement
and
was
the other dues
executed between
to the
the
railway authorities, including the enhanced arrear fee with applicable interests. Stop. Nevertheless, by the impugned order / communication, the petitioner was directed to vacate the wheelbarrows from the platform in which it is installed by 31/1/2026. So, counsel for the petitioner submit that this drastic action is not preceded by any prior notice, and as a consequence, the petitioner is unable to address her grievances before the authorities, as no prior notice was issued. Stop. The petitioner, being a senior citizen and who runs the said stall, does not have any other means of income, and therefore this sudden and abrupt notice stated, communication dated 9/1/2026 has an effect of interfering with her constitutional rights, including her rights to livelihood. The learned counsel therefore submits that the impugned communication and the actions contemplated are contrary to the policy and the law, and therefore should be interfered with, set aside and quashed. And the hate provision to be disposed of, adequate entry orders to granted. Yes, Madam Gail, anything to submit?
Just now I don't have any instruction, my lord, so interim may not be granted, some short date may be granted.
Because tomorrow is
Yes.
the vacation order.
My lord, short
That
date
they
or at 2, my lord, at 2 I will bring the
MS
instruction.
Gayan appears on behalf of the NF Railways. She submits that she does not have any instructions as on date. Therefore, praise that
I had already served the sixth copy of copy
Matter-
to the SDI officer.
how much time do you require for instruction?
For instruction, my lord.
The matter be listed after a week. Accordingly, At this stage, although notices are not issued, the respondent counsel is permitted to obtain her instructions. Matter is directed to be listed again on 11th
Yes, my lord.
February.
Yes,
Stop issue notice on the interim prayer, returnable on 11th, till the next date fixed. No forces action be taken in pursuance to the communication dated 9/1/2026 issued to the petitioner. How many petitioners?
2 petitioners, your lordship.
Where is the second petitioner?
Second petitioner is Umakant Rao. He is in the.
Where is the first petitioner's notice?
Yes, your lordship. 239, kindly have,
239 is Umakant.
Umakant.
Ah.
And there are the, your lordship, kindly have
Which notice are you challenging?
both notice, because both are the similar.
Which are the notices? Page numbers?
Page number 239
Ah.
of the Umakant Rao, and page number, your lordship, 242 of the Jayanti Bhaumik.
So impugn communications both dated 9/1/2026, Hibo within bracket annexure 11, page 239, and annexure 12, page 242 respectively to the writ petition.
Your lordship, if your lordship may have my request, kindly put up on 18th, because I have to come from the Allahabad.
Or at least on 13th.
Your lordship, there is a request because 12th is the fixed
13th,
date.
13th.
No, 12th is the fixed date at their 3 cases at Allahabad.
Which date do you want?
18th, your lordship.
Oh, you want it on 18th?
18th, your lordship.
All right, 18th.
18th Feb.
Uh,
Deeply.
Master bless.
Yeah. My lord, the petitioner is the, my lord, president of, my lord, Dokkin Business SS Limited. The, my lord, 8 members, they have been, my lord, declared uncontested, my lord, elected. Then they, my lord, hold the, my lord, annual general meeting. In the annual general meeting, my lord, there was no quorum. So meeting was adjourned. Immediately, my lord, the, my lord, the management committee has been, my lord, dissolved by the, my lord, district officer. Lordship will find at page 48. Page 48 is the, my lord, input order.
Yes, then?
Yes. Now, this order, my lord, is in gross violation of section 34 of the Assam Cooperative Societies Act.
Cooperative society. Yes.
Section 11. Lord, section 34.
Give us a copy if you have.
Sure.
Yeah.
No.
It'll be a.
Amendment 34.
Section 34.
Section 34. 34, my lord, subsection 2. Yes. It says, my lord, quorum of meetings of the General Assembly. Now subsection 2, lordship will find. If within the 1 hour from the time fixed for meeting of the annual general meeting, a quorum is not present, the meeting shall stand adjourned ordinarily to the same day in the next week at the same time and place. But the chairman of the meeting may, however, decide to adjourn the meeting to a later date, not later than 15 days or as may be specified in the bylaws of the society. Now, lordship, kindly see the impugned order was, my lord, issued on 26 November 2025 and AGM was held on 19/11/2025.
So before expiry of the 15 days, they have issued the impugned order.
No, it was supposed to be held on which date?
It was fixed on 19.
19th of November.
Yes, 19 there was no quorum. So from 19 we get
Where,
15
do
days
you,
time.
where is that minutes?
Yes, minutes. On page 36, Lordship.
Yes.
They were uncontested declared on 11. Today on 12/11/2025, an executive committee meeting of the so-and-so has been held. So-and-so regarding selection of the chairman of the Dokkin Business, regarding selection of the vice chairman, so-and-so.
Then?
Yes. Then Lordship kindly see page 40. Page 40, my lord. It says, my lord, 19/11/2025, regarding another date for holding AGM of Dokkin SS Limited due to the absence of quorum of the AGM held on 19/11/2025.
What happened on 22?
My lord.
What happened on 22nd? You wanted to hold a meeting on 22nd.
Yes, 22nd.
What happened on?
My lord, 22nd, my lord, meeting was not held because the officer was not authorized by the my lord, ARCS. So we could not hold the my lord, AGM on that particular day. And thereafter, my lord, on 26th, my lord, the committee has been dissolved. Now, our limited period, Lordship kindly see page 50. Page 50 is the my lord, appeal under section 111 of this act, my lord. This is pending before the my lord, Registrar of Cooperative Society. Not if your Lordship please to my lord, direct the Registrar of Cooperative Societies, take my lord, note of this appeal and dispose of the same, will be my lord.
Yes, Mr. Talukdar.
Yes, my lord, otherwise there would have been no difficulty. But the order, my lord, at page 48, additional register, my lord, she is exercising the power of the delegated power of the registrar. So therefore, my lord, essentially this order is amounting to pass by the registrar. So therefore, my lord, the appeal cannot lie before the registrar. The appeal is before the registrar. It should go before the state government. So therefore, that
It's
appeal
for
is
your registrar to decide that and send it to state government or whichever officer is competent. Why are you troubling the petitioners? They have to file an appeal before the registrar. They have filed it.
No, my lord. Under the act, they have to file before the state government. It is the provision of the act, my lord.
Then why have you filed it? Under what provision?
Yes, 111, my lord.
111.
Yes. No, if your lordship says, my lord, then that can be referred to the state government, no problem. But in terms of the act, my lord, it is the state government, which, my lord, is the
Shall
competent
lie to the
authority.
registrar.
My lord, no, 1112, my lord. 1113, my lord, 3. One is the appeal before the register, passed by any. My lord?
The order was passed by the assistant registrar.
No. Order was passed by the additional registrar, yes.
Additional registrar who was officiating as a registrar also.
That power is delegated, man.
Delegated?
Delegated under the act.
Where?
Well, there is a notification. The power your lordship will find under section 3, my lord. Section 3(2). There is a notification to that effect. The additional registrar of the BTC, my lord, will act as the my lord, registrar. This is the power under 3(2), my lord. The state government may also appoint any other person or persons to assist the registrar and may by general or special order, there is an order, my lord, in writing, delegate to any such person or persons all or any of the powers and responsibilities of the registrar. So there is a notification, my lord, delegating the power of the registrar under section 3(2) to exercise the power, my lord, in BTC.
So now it is to be
By the state government.
State government means principal secretary.
My lord, principal secretary, my lord. Now there is a principal secretary.
Secretary BTC has been.
Yes, BTC, anything?
I've been told by Senior Counsel Mr. A.K. Puya, Senior Standing Counsel of the BTC, Lordship, Secretary has been entrusted with that power of registrar, Secretary BTC. So Lordship, he'll do as per your Lordship observed, He'll do the needful.
But it has to be placed before the secretary then.
Yes.
Proportional power to asset.
Corporation is just interested.
Yes, Mr. Bhuya, anything to submit?
This cooperative, my lord, is an entrusted subject, my lord. In that view of the matter, appellate jurisdiction has been entrusted to the secretary BTC.
Secretary BTC.
Yes.
All right.
Under that will be, my lord, under 111 subsection 3.
So this has to be now heard by the secretary BTC.
Yes.
Yes, fine.
If they are, my lord, intend to be heard, my lord, by the
Heard,
It's not a party respondent here, my lord.
doesn't matter. Heard, learned counsel for the party is the petitioner. You were elected as a what, director?
Yes, initially directors, now petitioner is the president. Chairman.
Is the chairman of the
my lord, only one
Thin SS Limited Cooperative Society. Yeah.
one prayer, my lord. In respect of the same cause of action, another writ petition is pending, 6668. My lord, they have essentially challenged, my lord, made the same challenge.
No.
So both the writ petitions, my lord, should be, my lord, heard together.
That was
Because
not the
otherwise that would be pending, my lord.
same issue, that is different issue.
No, same issue. That board is, my lord, dissolved. Only the order was not annexed. In that case, this particular order was not annexed. And my learned friend ought to have apprised this honorable court, my lord,
Yes,
before
we have
starting.
already yesterday.
Huh?
We have already yesterday.
Huh?
We have already yesterday in our petition. This is
That
several
should
cause
be-
of action.
No, what are you challenging in the other writ petition?
Other writ petition, my lord, they were, my lord, not allowed to hold the AGM and election.
So that has become infractious today.
Yes, but virtually that is become.
But you'll have to bring it to, you'll have to close the proceeding.
Yes, that will.
In that case, my lord, let it be posted, my lord, if my friends, my lord, Chairman, let it be posted on Monday along with that writ petition.
All right, list this matter again on Monday, second, along with WBC number
6668/25, my lord.
6668 of 2025.
On Tuesday, my lord.
Tuesday.
Tuesday.
My lord.
Tuesday.
Obliged.
But there is a very serious issue, Madam, regarding bank fraud. The mother of the petitioner was a school teacher, Madam. After retirement, the retirement benefit was credited to her state bank account, Madam, at Borobari Jaipur branch, Madam. Almost 37 lakh rupees was credited to her account. Then subsequently, Madam, subsequent to retirement, Madam, she died, Madam. She had two accounts, one salary account, the other was, Madam, joint account with the father of the petitioner. In these two accounts, Madam, total 46 lakhs rupees were there. And the entire money was withdrawn by some miscreant on different dates, my lord. And different amounts on different dates were withdrawn. And my lord, starting from page number 12, Lordship will find the bank statement, my lord, of the deceased account holder. Page number 13 will show, my lord, starting from rupee 1. Page number 13, my lord, debit portion. 1, then 2,98,000, again 10 rupee. Then 98,000 to the, my lord, different amounts were withdrawn, my lord, including 5 lakh rupees at a time, my lord. Lordship will find the last amount, page number 1616, 5 lakh rupee was withdrawn at a time, my lord. The bottom portion of the debit column, my lord. Lordship will find. So in this way, my lord, then again page number 17, my lord, 5 lakh on the front portion, 5 lakh 4 lakh 50,000. So in this way, my lord, total 44 lakh 63,388 rupees was withdrawn from the two accounts of the petitioner's deceased mother. After this, my lord, well, I came to know regarding this withdrawal of money. I approached the branch officials several times, filed representations. Then I approached the Cyber Council at Panbajar. The Cyber Council, my lord, registered my FIR, my lord, as GD entry, my lord. That Lordship will find page number 20, page number 28, my lord. This was entered by GD entry number 009 dated 17/7/2024. Then I was instructed by the Cyber Council to inform the matter to local police station. Then, my lord, on the same day, I lodged an FIR before the Dispur police station. That FIR was registered as Dispur PS case number.
What is your prayer? What do you want?
My lord, I want that, my lord, that the bank officials.
What has
without-
happened to these FIRs? What is the status?
My lord, my prayer is that, my lord, the matter be.
What has happened to the FIR after your file?
My lord, nothing have happened as of
Then
now.
what steps have you taken? Other than filing the writ petition?
My lord, considering the seriousness of the matter, I want that the matter be.
Therefore, you had filed an FIR. Who filed this FIR?
I filed this FIR.
You filed this FIR.
My lord.
What has happened to the FIR? What investigations have been carried out?
My lord, police could not do anything, my lord. So I want that the matter be investigated by, my lord, CID, my lord.
CID.
CID, my lord. This is my prayer, my lord. Because
Oh.
considering the seriousness of the matter and my lord, involvement of the bank officials.
You are an astute counsel. You know that once an FIR is filed and no actions are taken, there are provisions under a statute.
Yes, my lord. I
Have
should
you
approach
taken
the.
recourse to that? Have you taken recourse to that?
My lord, I did not approach the commissioner of police or the even the court also.
So you want the court to continue the investigation?
No, my lord, I want that, my lord, matter be investigated by CID, my lord.
Why? What
Because,
is wrong with the state police?
my lord.
Why are you casting an aspersion on the competence of the state police?
No, my lord, considering the seriousness of the matter, since.
They are competent to handle seriousness.
Lordship, my lord, they are competent.
Then what is their difficulty?
The FIR
Are
was
you
also.
making any veiled allegations?
But almost 1.5 years have passed, my lord, but they have not done anything as of now, my lord, till date, my lord.
Commissioner of Heard Level Counsel for Parties. The petitioner is aggrieved that the bank accounts maintained by his late mother in her name and as also in the joint name of the late mother and the father contained a total amount of how much?
44,63,388.
44 lakhs
63,000.
63,380.
380. 88.
88. Stop. According to the petitioners, some miscreants had withdrawn this amount, entire amount on different dates. Petitioner has filed an FIR on 17/7/24.
17.
Both in under the Cyber Crime Unit, Panbazar, as well as Dispur Police Station, and also before the area manager SBI. Stop. Petitioner is before the court with a prayer that the investigation be directed to be conducted by the CID.
But CID is also.
There is no averment in the petition as to what steps the petitioner has taken for the failure of the police authorities to undertake the investigation, and on the basis of the FIR stated to have been filed, which are enclosed as annexures 8 and 9. Needless to say that under the BNSS, there are provisions, statutory provisions available to the petitioner for redressal of his grievances in the event the FIRs filed by the police, before the police, are not given its due or legitimate consideration. Stop. Under such circumstances, this court does not find any merit at this stage to entertain the writ petition. Accordingly, the same stands dismissed. No order as to cost. However, dismissal of the writ petition shall not curtail the right of the writ petitioner to approach the appropriate authority and forums prescribed under BNSS.
In the event, my lord, with liberty, my lord, I may be allowed to.
Be given you liberty to file it.
In the event, my lord, the alternate remedy does not, could not, my lord, give the result.
That you can come, needless to say that. Yes.
Here in this matter, my lord, the petitioner purchased a plot of land, my lord. And accordingly, my lord, her name was entered as a co-partner. Her name was recorded in the record as a co-partner. Subsequently, my lord, she has filed an application before the circle officer for separation of partner, my lord. But that application has not been considered by the circle officer. Very simple prayer.
I'll get the instructions.
Heard counsel for parties, the state council will obtain instructions on the application for application filed by the petitioner for what?
Separation of partition.
Separation of the
Partner.
pattas before the competent authority. Let these instructions be placed before the court. When can you get it?
2 weeks, man.
2 weeks on 20?
27, my lord.
Huh?
On 27, my lord.
27th, all right, 27th. Although notices are not issued, extra copies be furnished within 3 working days to the State Council.
Obliged.
18.
My lord. The
Yeah.
matter in nutshell is that the petitioner is an accredited journalist, that is freelancer, and a media gallery pass for the intersession of the Assam Legislative Assembly scheduled from 25/11/2025 to 29/11/2025 was issued to the petitioner. But in spite of having a valid pass, the petitioner was forcefully removed from the press gallery without assigning any reason. The petitioner filed a representation on the very same day, that is on 25/11/2025, to conduct an inquiry into the matter and to restore the right to attend the assembly session, but no action has been taken till then. This was an arbitrary, unjust, and unfair. And so the petitioner has approached before this honorable court and
Get your instructions.
Lordship, I am appearing only for respondent number 1. Here are SC, my lord, in respect of Legislative
Who
Assembly.
is appearing?
Mr. Bunyas, AK.
We have not received the copy and our name is also not shown.
Probably copy not served, my lord. Let it be.
You serve copies on the
Monday
standing
or
council
Friday.
today. We'll take it up on Wednesday. 11, sorry, 4th February. You serve copies now. You get your instructions by 4th. List this matter on 4th. Permitting the petitioner to serve copies of the writ petition to the standing council.
SC may be reflected, my lord, in the cause.
Respondent number 2 and 3. We are fixing it on 4th. So even if it is not reflected, note it appear in court. Along with your instructions. Yes. Yeah.
19. Wait, Lordship. Lordship, in this case, I have not been granted a sale permission, Lordship. I have applied in the month of August, Lordship. Till date.
Again, instructions here.
Lordship.
Heard counsel proposes. Learned government advocate and government will obtain instructions as to why the petitioner has not been granted sale permission for the plot of land he proposes to sell. List again on 11th.
Lordship, I'll try.
Extra copies be furnished within the course of the day.
Lordship, one line may be granted. That pendency of this case. may not be-
Pendency of the case, writ petition shall not be a bar to grant the sale permission break flow by the petitioner.
Highly your business.
20.
May I please, Lord? Petition of son was died due to electrocution on 22nd July 2025. In this regard, the petitioner has filed a representation before the respondent number 6.
Will issue notice here, heard, Learned counsel for party will issue.
Chief Electrical Inspector report is necessary, my lord.
And Mr.
SU.
I am for 1 and 4.
MSM Burman represents 1 and 2. No, 1,
1, 4 and 5, my lord.
1, 4 and 5. And Mr. KP Pathak for respondent number 2,
3, 6, 7 and
6, 7 and 8. Since the respondents are represented, notices are waived, extra copies will be furnished within a period of 1 week from today. This again. After the return of visit.
Obliged, my lord.
6th of March.
My lord, kindly fix the date, my lord.
6th March.
Obliged, my lord.
Supplementary, no motion attached 43. May I please, your lordship? My lord, similar petitions had been disposed of, my lord, and an order had also been annexed.
Page 86.
Yes, yes, my lord, may be pleased to find at lecture 9, page 86, my lord.
What do you say, Mr. Sharma? We'll take it up on 4th. Let him get instruction.
Lordship, or
Disposed of, my lord, because the deputy commissioner will ultimately take the call, my lord. I have to respond there.
but here in the notice, Lordship, if we go by the notice at page 95, yesterday also Lordship has disposed of 2 meters, but those were the tenants, Lordship. But here in page 95, third paragraph, I am reading the vernacular one. সেয়েহে ধাৰা so and so অনুসৰি অহা 15 দিনৰ ভিতৰত this notice is of 29/12/2025 জনজাতীয় খণ্ডত ভূমি অধিকাৰ সাব্যস্ত কৰাৰ বাবে প্ৰয়োজনীয় নথিপত্ৰ প্ৰমাণ দাখিল কৰাৰ বাবে জাননী প্ৰেৰণ কৰা হ'ল। So it's a
Are you a
so-called
tenant or
notice.
occupant?
He has not.
No, no, my lord, I am residing in a land by virtue of the power of attorney, my lord.
Where is that power of
My lord,
attorney?
may be pleased to find that annexure 2, my lord.
Page number
My lord, page 47 is the original and type copy is at page 14. My lord, the
Lordship, he was already given time, hide that notice. He has not availed that opportunity.
No, no, I will.
Huh?
We have submitted.
Document নাই to.
জমা দিছিলে তো ন ৰেকৰ্ড জমা দিছে
Document নাই to. Annex কৰা নাই to.
আমি সেই হেৰি কৰিছো
So, most, in that case, Lordship, he has missed the bus, Lordship.
Yes.
No, my lord, my
Yesterday,
instruction
he was a tenant, Lordship. Accordingly, your Lordship has disposed of all those matters, directing him to place all those documents within a period of 4th of February or 2nd of February, and thereafter to be disposed of. Till that, no coercive action.
same order can be.
Now here, he has to, notice was on
29/12, my lord.
29/12,
within 15 days.
within 15 days. He did not avail that opportunity.
No, my lord, in the last, yesterday's cases also, my lordship was pleased to extend the time, my lord, when we, my lord, did not supply in time, my lord. So, my lord, within a
Who is the actual owner?
my lord, the actual owner is Sam Pator, my lord, Jagannath Pator.
Who will file the petition?
My lord,
Petition is filed by the tenant,
by the
Here-
attorney, by the attorney,
attorney holder.
my lord.
In yesterday's cases, the owner of the plot of land, Lordship, they have filed the applications. And my,
Oh, attorney holder, can he file the petition?
Because, my lord, notice has been served to me, my lord.
You will pass similar orders so that the matter can be disposed of.
Lordship,
Where is that copy of the order? Yesterday, is it available?
No, my lord, it is annexed, page 86, my lord.
no, that is not the order.
No,
Yes, Lordship, that item number. Lordship,
Yesterday's order is different.
না না লাগে মই আইটেম নাম্বার কিটা কৈ দিব পাৰিম লৰ্ডশ্বিপ লেট মি
In this line of, no, no, it order, it police.
17 আছিল ন
কিমান আছিলে যোৱাকালি order দিলে?
item number 17 and 18 lordship
Yesterday.
yesterday's those were the owner of the plot of land were before your lordship in those cases and on behalf of the notices were issued on tenant lordship that's 17 and 18 accordingly your lordship has directed them to place all these documents within 2nd of or 4th of February and thereafter lordship
Will pass similar order.
But this confirm. The order to sign. Main is a niki. Not more. Yes. This is item 46, right?
lordship
And 47?
47 is, my lord, similar to the yesterday's matter, my lord, it's a Tongia forest is involved, my lord.
yeah forest is there
So my lord maybe was pleased to fix those matters on 12th of February, my lord.
there
This
is
matter
some
can-
small difference in this matter. In this matter, the paragraph where they have said that they are under the Tongia system, no such document has been enclosed, and that paragraph is sworn to knowledge. If your lordship turns to paragraph number 8,
Yes.
there is some doubt as to the antecedents. Paragraph number 8, those statements are made. If your lordship turns over to the next page on 13, it's at page number 12. If your lordship turns to page number 13, that portion for annexures has been removed, and I checked the court copy. This has been sworn to knowledge. There are no records whatsoever in the petition that they are under the Tongia system.
Lord, no, my lord, my learned friend submission regarding the removal of the annexure and no record.
No, I'm not saying it's been removed. I'm saying annexures are not there.
My lord,
There are no no
my lord,
documents on record.
these land deed and the sale deeds, my lord, which we have exhibited, my lord, is basically from this Tongia system, my lord. The people who were originally, my lord, Tongia resident, huh?
So we take it up on 12th if it is fixed.
My lord.
similar matters.
Till then, my lord.
No. Will the matter be listed along with WPC number?
My lord,
739.
739.
739.
7391, 2020,
25.
2025, 7391, 2020.
My lord.
25. On 12.
My lord. Till then, my lord, no.
Till then, nothing is going to happen.
My lord, nowadays very risky, my lord.
Oh.
Overnight something may happen, my lord. Status quo, my lord, I don't did.
Status quo is on
Right.
till
Obliged.
12.
My lord, in the other matters, there was
Steps be completed within 2 working days.
My lord, my lord.
Yes.
in the other matters, there was direction that no coercive steps be taken. So,
So no coercive
Yes,
step,
very
whatever
well.
order is there.
very well.
Pass it.
Obliged.
Yes.
Please,
No.
my matter is almost similar, my lord.
Oh.
I have been allotted land, my lord, under the agreement, my lord. Agreement, my lord, at page 21, my lord. And
Your documents are there.
my documents, all documents are there, my lord.
Agreement by whom?
By the Government of Assam Department, Forest Department, my lord.
Forest Department.
Yes,
Yeah.
my lord.
Appears that the first agreement was with the predecessor
Yeah.
of the petitioner number 1. So it may be fixed on the 12th, your lord.
All the petition I have, their legal document, my lord. And
All right.
they are also,
This matter also be listed on 12. Mr. KP Pathak appears for the Forest Department. And where is the notice?
notice, my lord, at page number. Uh, 206.
206.
The translated copy and my lord 208, the vernacular.
206.
206, cancelled. Yes, page number 206. 6 originate. One is over. They are legally settled, my lord, dwellers of the said forest village.
Council for parties, these matters containing similar matters are fixed on 12th. Matter also be listed on 12th.
WPC 7390.
Along with WPC 739 of 2025. 7391.
7390.
Mr. KP Pathak with this for the respondents. The extra copies we furnished. And till the next date fixed, no coercive action in pursuance to the impugned notice.
No coercive. Obliged.
Well, the petitioner provided 4 godowns to the various entities, my lord. And those entities got its some registered in the GST. And there were some allegations of the GST evasion against those 4 entities. Now, a SOCOD notice was issued, common SOCOD notice, my lord, along with those 4 entities to me. Tax evasion, my lord, demand was raised on those 4 entities, but against me, only penalty was proposed in the section 120 and 121, 19 and 121A. Now, you'll also kindly see the finding of the authority while imposing the penalty. The adjudication order, you'll also find at page 189. 189, no? Huh? Finding. And summary, my lord, of page 294.
Two 294.
My lord. Para 63.12. I mean, this relates to me, my lord. On the basis of the overwhelming evidences, seizure documents, records, statement, and the corroborative materials, absence of any genuine business activity, non-existing premises, and the role played by so-and-so Betala in facilitating fake invoicing and illegal movement of the goods, it stands established that he is a key facilitator, he is beneficiary of the fraudulent transactions, he used registration details of 4 entities fraudulently, and the transactions occurred by at his instance. Therefore, the penalties imposed in section 122(1)(a) and 122(1)(19) of the CGST Act are hereby confirmed against the C so and so. Now, your lordship may kindly see section 122.
GST.
I'm giving you the book.
Yes.
€122, €119.
Yes, 122.
€119. You also got it. Issues any invoice or documents by using the registration number of another registered person. So if anybody issues invoices using the registration number of some other person, then the penalty under section 122(1)(19) is leviable. Now we'll also be seeing the finding. There is no finding that I have used the invoices, issued the invoices using the registered number of some other person. I have not issued any invoice at all. Now we'll also see the bottom, my lord. After that, after 21, my lord.
Yes.
He shall be liable by a penalty of 10,000 rupees or amount equivalent to the tax evaded. Now, in my case, there is no demand of tax at all.
the tax demand has been raised on some other persons and the penalty has also been imposed on them. Now, your lordship is aware, my lord, that penalty cannot be imposed for the tax evasion by some other person. Now, first of all, there is no allegation that I've issued any tax invoice. If I've not issued any tax invoice, the question of imposition of penalty under section 200, 120, 119 does not arise. Secondly, it has to be calculated at the amount of tax evaded. There is no tax demand on me. It is only a penalty under section 122, 119 and 120, the separate section. Unless there is a tax demand or tax evaded, the question of imposition of penalty under section 122, 119 does not arise. Now, your lordship sees the second penalty, my lord, which is 122, 1A, my lord. Your lordship got it, my lord. 1 capital A.
Yes.
Any person who retains the benefit of the transaction covered under clauses 1, 2, 7 and 9 of subsection 1 and at whose instance such transaction is conducted shall be liable to penalty of an amount equivalent to tax evaded or input tax credited availed of opposition. First of all, this section, section 122, 1A, was inserted by the Finance Act of 2020.
And this transaction relates to?
18, 19, 19, 20 and 2021. Now, my submissions are there in this regard, my lord. First, when I have not issued any invoice at all, when I have not transacted, it clearly says that I have not transacted in business. Then question of returning the benefit does not arise. Secondly, the section having come into force from 1st January 2021, the imposition of penalty for 18, 19, 19, 20, 2021 does not arise. Thirdly, for 1A also the penalty is equivalent to the tax evaded. When there is no tax, the question of evasion of the tax does not arise. Apart from these submissions, my lord, apart from the verity of this submission, I am not going into multiple years, the so-called notice. I am not going into this issue. But so-called notice for different entities, a common so-called notice and common adjudication order, that is not permissible at all. You can't issue a so-called notice and adjudication order against 6 SSEs by a common order and pass a common adjudication order. Secondly, for imposition of the penalty, no time limit is prescribed. But since the word is tax evaded, and tax evaded, the maximum is the 5 years under section 74. So after 74, time limit has expired. The penalty cannot be imposed because tax evaded cannot be determined at all. But I am not going into those issues, my lord, at the present stage. At the present stage, my lord, 122, 19 and 122, 1A, the mandatory preconditions have not been fulfilled at all. The no finding that I have issued any invoice, thereby 122, 119 does not apply.
Can it not be also interpreted that tax evaded means tax evaded in respect of the entity whose account you were being alleged to have misused?
122, when we say tax evaded, tax evaded, my lord, by your lordship, first see you in the top 122, where a taxable person.
Right.
So the person who is engaged in the sale and purchase of goods, it's not so that any person can be said that we will impose the penalty, because penalty has been imposed against those persons also. And the same sections, provisions.
Yes.
So, my lord, 122, 1A penalty is absolutely illegal because it is prior to the bringing to force of the 122, 1A section itself. And secondly, there is no finding that I have issued an invoice. And if I have not issued the invoice, the question of imposition of penalty under section 120 to 119 does not arise, subject to, my lord, whatever your lordship has observed. But that will be all calculation. But if the mandatory precondition is not fulfilled, the question of imposition of penalty does not arise. So in my humble submission, my lord, this case a fit case for which needs consideration by your lordship, my lord.
What about alternative remedy?
Lord, when the jurisdiction is not there, 122(1)(a), when the section was inserted in 21, and one is imposing penalty for 18, 19, 19, 20, 21, that is absolutely without jurisdiction. Secondly, penalty, my lord, imposition penalty, mandatory precondition have to be fulfilled. If it is not fulfilled, then the question of the my lord, alternative remedy is absolutely without jurisdiction. And in Godrej Sarli case, my lord, the lordship has seen, my lord, when the question of law arises, then Supreme Court said that, my lord, the writ petition should be entertained.
Yes.
Subject to the judgments to your lordship has given name of Sarma and others, where lordship has dealt with exhaustively on the alternate remedy. My lord, I also refer to those judgments. I could take a printout only in the morning, so I have not bought it.
All right. Yes, Mr. Setia.
Lordship, what is common in this case is, my lord, it's a common principal place of business that has been shown by the, my lord, 4 entities, my lord, and that is owned by the petitioner. And my lord, on petitioners, my lord, he has facilitated those companies to, my lord, utilize fake input tax credit, my lord. And therefore, he has been implicated, my lord, in this case. Your lordship may see the show cause notice, my lord, at page 69, my lord.
You show us from the order in original because
Lordship.
these findings must be there.
My lord, yes, lordship, that starts from page 189, my lord.
Finding is 294.
Yes.
My lord, it's relevant portion, my lord, page 191. It starts from page 191, my lord. Para 2. A letter dated 25/6/21 was received from Mirror Journal Unit DDCI, wherein it was informed that one entity, namely Khalid Traders, had availed ineligible ITC on the strength of invoices issued by fake firms. In the said letter, it was requested to take necessary action against the entity as the entity falls under the jurisdiction of this journal unit. Acting upon the said information, search was conducted at the registered premises of Khalid Traders situated at so-and-so. The premises was found to be locked and there was no mention of the Khalid Traders. Thereafter, the officers inquired about the owner of the said premises, which appeared to be Sri Nitesh Kumar Singh. Sri Nitesh Kumar Singh, on being asked, informed the rent agreement of the said premises was executed to him by Sri so-and-so, proprietor of Khalid Traders. However, neither the possession was taken nor any rent has been paid, as he was the possessor of the keys. Thereafter, the said premises were searched, nothing so-and-so. Thereafter, my lord, see para 5. Statement of Sri Hasbir Betala, he is the petitioner, was recorded under section 70 of the so-and-so Act on 26/6, wherein he entirely admitted to the fact stated by Sri Nitesh Kumar Singh that he does not know Sri so-and-so, and the rent agreement was prepared and executed on the direction of so-and-so. He also stated that he has godown premises situated as opposite to so-and-so, which was used to store packing materials of pan masala and jarda. He further stated that the said packing materials was sent from Delhi with the instruction of Sri so-and-so to deliver to the said goods to the factory of Kamla so-and-so. The loading, unloading and transportation work was taken care by him as per instruction of Madan Jena, and he used to receive consideration from him only. So this Jena, he is also, my lord, the notice number 6 in this present case, my lord. So, my lord, the relevant observations of his involvement, petitioner involvement, my lord, at page 286, lordship. My lord, from para 61 to 88, lordship.
Page 288.
I also find that the department elevates Sri Hasbir Betala for his role: 1. Provider of premises and facilitator of storage. Sri so-and-so provided the menace to go down premises at opposite so-and-so, which was used to receive the store printed, laminated papers, aluminum foil, etc. so-and-so, on behalf of the 4 entities. That is, my lord, the notice number 1, 2, 3, and 4, my lord. Goods found at the Goodams were seized during search on so-and-so. Drafting and supply of rent agreement used for registration. he drafted, notarized, and supplied the rental agreements used to establish the national principal place of business of 4 entities for the purpose of GST registration, despite having no personal acquaintance with the purported properties directors. These agreements were found and shared with Sri so-and-so to secure registration, subletting and handing over others, operational controls. So therefore, my lord, there was clear observation that, my lord, the present petitioner, he was the notice number 5, my lord. He was involved and, my lord, he facilitated the, my lord, notice number 1 to 4, my lord, to obtain, my lord, false input tax credit, my lord. So, my lord, under section 122, my lord, 119, my lord, that's referred to, my lord, documents also, my lord, as your lordship may see, my lord. Penalty for certain offences, my lord, subsection 19, my lord, issues any invoices or document.
We will issue a notice here. Heard Dr. Yoksaraf, Senior Counsel, Assistant by Mr. S. J. Setia and Mr. S. Setia, the standing counsel appearing for the GST department. The petitioner is agreed by. You're challenging the show cause also.
The show cause, although it after the adjudication, but side by side, we have challenged the show cause.
The show cause dated so and so, as well as the order in original dated so and so, passed by the jurisdictional officer, imposing penalty on the petitioner. So,
Under section 122, 119 and 129.
under section 122(19),
119
119,
and 122, 1A.
and 122, 1A. Stop. The learned counsel for the petitioner submits that the allegation made against the petitioner is that he had facilitated other entities of falsify benefits under the GST and input tax credit, is it? ITC.
No, it is not allegation. There is no allegation.
No, the allegation is that he has allowed
Some other person.
other person.
Hello.
Stop. Under such circumstances, the notice, show cause notices were issued, which were replied to, and finally by the impugned order dated so and so, the demand raised by the show cause notice stood confirmed. Learned counsel appearing for the petitioner submits that under the provisions of section 122, 119, the penalty is to be imposed in respect of a taxable person who issues any invoice document by using registration number of another registered person. Stop. The further allegation is that under section 122, 1A, any person who retains the benefit of a transaction covered under clauses so and so, so and so, so and so, and whose instance such transaction is conducted shall be liable to a penalty of an amount equivalent to the tax evaded. Dr. Saraf submits that these provisions under which the penalties are imposed are not applicable to the petitioner inasmuch as there is no allegation or finding against the petitioner that he had issued any invoice or document using the registration number of another registered person. So further, the application of penalty, imposition of penalty under section 122, 1 capital A is also not applicable inasmuch as the same was brought into the statute by the Finance Act 2020 with effect from 22nd of December 2020.
Okay, effect from 1/1/2021. 1/1/2021.
1/1/2021. And The period of transaction alleged against the writ petitioner pertains to which year?
18, 19, 19, 20, 2021.
18, 19, 19, 20, 2021. So, under such circumstances, the learned senior counsel submits that the imposition of penalty on the writ petitioner by issuing a common show cause notice is totally contrary to the provisions of the Act and the rules, and penalty cannot be imposed on the grounds on which it is sought to be imposed against the writ petitioner. Being agreed, the present writ petition has been filed.
So about tax evaded also. The tax evaded submission also.
Dr. Sarath also submits that the allegation is that there is no finding against the petitioner for evasion of taxes.
No, there is no tax demand also.
Submits that the penalty is also imposed on the ground of evasion of taxes by the petitioner when there is no finding or demand by these GST authorities in respect of the petitioner for recovery of any taxes sought to be paid, held to be paid by the petitioner. So, under such circumstances, he submits that the impugn order in original, insofar as it relates to the writ petitioner, is contrary to the provisions of the CGST Act, as also the law declared by the Apex Court as well as by this court, and should therefore be interfered with, set aside, and quashed. And during the pendency of the writ petition, the same should be suitably stated. Where Mr. S. Setia appears for all.
2 to 4.
2 to 4. Anyone for CGC?
No.
Elias A. Gayan appears for respondent number 1. The Mr. Setia submits that there is a clear finding that the petitioner has facilitated uses of
Uses of, my lord, the same principal place of business for all 4, my lord, tax evaders.
Same place of business for all the 4 tax evaders. And before the authorities, he has admitted that he had a ground which he had in which he had allowed the other 4 entities to operate their business from by subletting a portion stock. Under such circumstances, the learned standing counsel submits that there is no infirmity in the proceedings undertaken by the GST authorities by imposition of the show cause, and the conclusions and findings and the imposition of penalty by the order in original. Having heard counsel for parties, this court is of the view that the matter will require consideration. Therefore, let notice issue returned in 4 weeks. Since the respondents are represented, notices are waived, extra copies be furnished within a period of 1 week from today. Upon careful perusal of the pleadings, writ petition, and the order in original, as also the provisions of section 122, 1 within bracket Roman 19 and 122, 1 capital A, it is seen that section 122, 119 is for imposition of penalty when a taxable person issues invoice or documents by using registration number of another registered person. So this on the facts urged before the court, and as is evident from the order in original, from a prima facie does not appear to be correct insofar as the writ petitioner is concerned. More particularly when there is no tax demand made against the writ petitioner. Stop. That apart. Penalty under section 122(1) capital A is imposed when for the assessment year 18, 19, 19, 20, 2021. When it is seen clearly that section 122(1) capital A was inserted in the statute with effect from 1/1/2021. So at least insofar as if an assessment years 18, 19, 19, 20, 21, 22 is concerned. 19, 20, 18, 19, 19, 20 is concerned. Prima facie, it appears to report that section 121, 122(1) capital A may not be applicable to the writ petition. Under such circumstances, let the respondents complete their instructions, file necessary affidavits. In the meantime, until further orders, the impugned demand made pursuant to the order in original dated so and so far as the writ petitioner is concerned, shall remain still. Only as far as the writ petition.
Yes, in respect to the petition.
Lordship, my submission may be recorded, my lord. The notice may be issued on interim also, my lord.
Notice on the interim there. Counsel to the respondent strongly objects to the prayer made for praying for stay or suspension of the interim order. For notice issued on the interim prayer. Returnable on 6th of March.
Lordship.
I'm obliged.
Till the next day.
Lordship.
Then we are, if we are issuing notice, then we'll say no coercive action.
Lordship.
Pursuant
The
to
same order, coercive measures.
He wants a hearing on the interim.
Let him, the order will next date.
Deeply obliged.
No coercive action. No?
Yeah, it was lordship. Lordship petitioner also the allot his lordship, and some of the petitioners purchased their land from their allot his lordship.
Yes, Forest.
Lordship, perhaps the writ petition has been founded on merely on an apprehension. If at all there is any procedure to or any initiative to
No, any notice he should know.
no notice,
Lordship,
any initiative was taken to evict the petitioners, then the procedure under writ appeal
to be
251.
Lordship, what happened, Lordship, recently, Lordship, the respondent number 6 with some officials, I have stated in para 5, Lordship, went to the place of the para 5, Lordship. They went to the place of the petitioners, Lordship, and said that this land are within the boundaries of the.
Oh, let them, they'll have to take steps by issuance of notice.
No, Lordship, then Lordship petitioner submitted representation on 6th January, Lordship. Thereafter, Lordship, on 7th January, Lordship, the respondent number 6 along with staffs, Lordship, went to the village and said that, Lordship, if you are not vacating automatically, we will vacate on or before 31st, Lordship. That is, they may be, Lordship.
When will it happen? When were you informed?
Lordship, para 8, Lordship, I have categorically stated, Lordship. Para 8, Lordship. Page 17, para 8, Lordship.
Para 8.
Para 8.
Yes,
Page 17, Lord.
Yes, read.
Although they have submitted the aforesaid representation dated 6/1/2026 before the respondent authorities on the same is still under consideration, but in spite of that, on 7/1/2026, the respondent number 6, along with some officials, came to the village of the petitioners and threatened them by saying that if the petitioners do not voluntarily vacate the respective lands, the forest authority will bulldoze their dwelling houses and vacate them on or before 31st January, Lordship. What is they may be, Lordship, that by Lordship petitioners approach before this Honorable Court. Lordship, the prayer of the petitioner is very simple, Lordship. Kindly, where is the petition? There, Lord.
Your petition was filed on 9th of January.
Yes.
Why is it listed today? Why?
I told Lordship it was some defects was there, Lord.
Defect. This is premature.
No, Lordship, kindly, Lordship, because the
You get instructions. If there is any steps taken by the authorities.
Very well. Or any initiative at all to, yes, very well.
Get instructions, we will take it up on 2nd.
very well. Lordship, no, Lordship, kindly till there, Lordship. Lordship, there may be, Lordship.
Without information, you are not explaining, you are filing a writ petition on 9th. It has come up before the court on 30th. We are permitting unlisted, listing of motions. Why did you not mention it if it was so urgent?
Lordship, it is some vacation was there, some days were there, Lordship, and some I have to type some copy. Translated some lots of Bengali, Lordship. Kindly, Lordship, they may be going to.
You get instructions by 2 p.m.
Very
Let us see what has happened.
Lordship.
Take instructions, approved.
Very well.
You give him extra copy right now.
Yeah.
Deeply.
51.
May I please, as a lordship?
Yes.
My lord, these two petitioners, my lord, belong to scheduled castes. My lord, and alleging that we are occupying land in a tribal belt and block in violation of the section 165 and that provision, similar notice had been issued. In fact, my lord, our forefathers also, my lord, having land, patta land in the said area. And we have also, my lord, annexed some of these patta documents, my lord. Jamabandi copies as well as
Annexer to my lord for the time being.
and some of the lands, my lord, we are now possessing through power of attorney as well as, my lord, sale deed has also been executed, my lord.
Where is the annexure?
Page 53, my lord.
Page 53, annexure 2, my lord, is a sale deed. Petitioner number 1.
My lord, it says, my lord, it's in a tribal belt area. One Khatan Das is the buyer, my lord. Seller is the Amal Chandra Patar. And my lord, this is, it's not an, it's not a registered sale deed, my lord.
Registered.
How can it be registered? In a
My lord,
tribal
in a
belt?
tribal belt area, my lord, a registered sale deed has been executed, my lord.
Documents, my lord.
And the notice is at my lord, page 129, it says, my lord, 29/12, 15 days to bring on records the documents supported in India support. And today is 30th, my lord. Have you filed and produce the documents? And they fail to take advantage out of this notice, my lord. Page 129.
What can be done now?
Similar order can be passed.
No, similar, but you don't even have any documents to furnish.
No, my lord,
It is admitted that you don't belong to that tribal area.
No, my lord, these documents, my lord, which I have annexed, is by virtue of, my lord, the sale deed as well as, my lord.
So why were they not produced before the authorities?
No, my lord, I will go to the authority. Perhaps, my lord, they have submitted, but without any acknowledgement. That's why I have not annexed, my lord. So I will submit again, my lord, within a time limit, my lord.
It can't go on like this, Mr.
Again, my lord.
No, my lord, very few people.
There must be some reason for that.
My lord, that is
why
correct.
you cannot go and file.
That is
Just
correct.
for the asking, we can't extend the date given by the
That
revenue
is-
authority.
that I admit, my lord.
Then so there is no reason why.
Only, my lord, this petitioner number 1 has got the.
Has the authority taken any decision? Probably not.
My lord, no, my lord, from the 29th, it has been given. It says till 15 days, my lord,
to submit the documents. And on the said land be reviewed within 1 month of the receipt of this notice. 1 month, my lord, yesterday gone by. Perhaps nothing has been taken place. And moreover, my lord, if your lordship go, only one shell deed has been given. Katandas. There are others, petitioners also, my lord.
What to do, Mr. Bhuyan?
My lord,
What to do?
we'll approach the authority, my lord.
You withdraw and approach. We will not give you any direction.
Yes, my lord. Otherwise, again,
Because, my lord,
with similar order, similar order,
Well,
similar
there
order.
has to be, see, you have to give us a reason, number one,
My
why
lord.
you failed to approach. Number two, you have to show us at least prima facie satisfaction that these are the documents I have it.
My lord.
Because of X, Y, Z reasons I could not show. Nothing is there.
My lord, may I take a week's time, my lord, to obtain instruction that perhaps they have submitted the documents
Alright,
on time,
do
my
that.
lord.
On the request made by the council for the petitioner, this matter again on the 9th.
My lord.
Mr. N asked for the state respondents. Yes.
Obliged.
May I please, Your Honor?
Yes.
Cooperative Society matter, my lord. The petitioner is been the president of the Cooperative Society since 2023, my lord. And no confidence was moved on 17/11/25, my lord. According to the register, my lord, appointed the financial officers to be part of it with regard to no confidence, my lord, voting, my lord. Accordingly, voting was held, my lord, on 24/12/2025, my lord. And as per the law, 3/4 majority is to be there. But it failed, my lord. Accordingly, for approval of this particular minutes, whatever has happened on 24/12, it was sent to for approval. Now, my lord, the person concerned, my lord, will kindly come to the impugned order 46 of 46 page 46 19(1). Wherein, my lord, I am reading the second paragraph, that is very important. Upon perusal of the board minutes dated so-and-so and the report of so-and-so Ranjan Deka dated so-and-so, it is clearly established that the president against whom the removal resolution was proposed participated in the voting and cast his vote in favor of himself, which was then counted towards the statutory 3/4 majority. These facts admitted in the society's own record, while the Assam Cooperative Societies Act 2007 expressly bars the president from presiding over such meeting. It is silent on voting rights. My lord, I am not the person who have, my lord, presided over this. It is the representative of the register who have presided over it. And this notice has been sent, my lord, with regard to this, that there will be new fresh with regard to this whole process, my lord. So this is beyond the law, my lord.
No, you were the.
I am the president, my lord.
You were the
No
president.
confidence motion has been moved against me. So register appoint the financial officer to conduct this no confidence motion. Voting were done, my lord.
No,
It has been.
no confidence against president and.
I was the president. Against me, no
You have a
confidence.
vice president also, no.
No, I am the president, my lord. So against me, no confidence motion was brought. So the register appoint the financial officers to carry on this no confidence motion. And on being presided over by the financial officer, who is the representative of the register, conducted this. But the resolution failed because 3/4 majority didn't happen. Now thereafter, for approval of these particular resolutions, my lord, minutes, it has been sent to the register office. Now this notice has been issued, my lord, wherein it has been stated that I have presided over the no confidence motion, my lord. That is untrue, my lord, contrary to the minutes. Secondly, my lord, it has been stated that it is silent on voting rights. So Act itself says, my lord, there is no bar with regard to the president casting votes, my lord. There is no statutory bar. According to him, there is a bar. So that bar is not been provided under the statute itself, my lord. And now.
What does the act say?
Act says, my lord, yes. 26. 36 for my lord will kindly come to. President or Vice President of Cooperative Society. I'm directly coming to the fore, my lord. The board may, by a resolution passed by 3/4 majority of the directors present and voting at a meeting held for removal of the president or vice president, such meeting shall not be presided over by the president or vice president against whom such resolution is to be considered. That's all. I cannot preside over. If I manage to get here, page number. Yes, may I take it to the minutes, my lord, at page 38. Type copy, my lord, page 38. I have not presided over, my lord. It's the minutes that has been, my lord. 24/12/25, my lord, 12 noon. A meeting of the board of directors of so and so, so and so, so and so. Today, 24 for the floor of no confidence against the president of so and so. Limited. The meeting is presided over Trilakya Ranjan Deka, senior accountant officer in compliance with
You're reading from where?
page 38, my lord. That's the minutes of the meeting, my lord.
38.
Yes.
Yes.
And at page 39, my lord, can you see the first line? The meeting is presided over by Trilakya Ranjan Deka, senior accountant office auditor in compliance with order dated so and so of ARCS Guwahati, my lord.
Yes.
So, my lord, the floor test with regard to getting 3/4 majority failed, my lord. And accordingly, minutes were prepared, my lord, and sent it for approval. Now, my lord, this impugn notice comes in, my lord. Again, my lord, they want to, my lord, conduct another no confidence motion, my lord. That is illegal, my lord.
Where is the voting 3/4?
3/4 is there, my lord. Yeah.
Somewhere.
Yeah, the account. 36/4, my lord, can we see? By 3/4.
3/4.
The board by a resolution passed by 3/4 majority. I have been sent this no impugn notice only because I have voted, my lord. There is no specific bar, my lord, with regard to voting, my lord.
Where is the notice again?
Notice at page 46, my lord. That's the order, my lord, wherein
What is purported to be carried out by the notice? What is
again
the-
fresh, my lord, no confidence motion, my lord.
Page 47.
47, last two paragraphs, my lord.
Last part, my lord.
24/12 passed by the board of directors of so and so limited for removal of president is hereby not approved and declared procedurally invalid and unenforceable. The board of directors shall convene a fresh meeting within 15 days in strict compliance with the Assam Cooperative Societies Act and the principle of natural justice. In this meeting, the president shall neither preside.
This calculation of 3/4 excluding the president, is it provided under some
No.
Yes,
notification?
yes, correct. Malo, this is in fact, this is the pertinent question. Reading from 36/4 does not appear that, my lord, the president is excluded.
He is only prevented from presiding.
Presiding.
Yes.
My lord, in fact, if the no confidence is against him, that will be presided by the vice president.
Vice president.
But, my lord, there is some irregularity I find from the minutes, my lord, of the meeting. It's not presided over by the vice president. Page 39.
Yes.
It's presided by over some other person, but that may not be, my lord, very crucial.
That is not the ground.
Yes, that is not the ground. And,
That
my lord,
was-
in fact, here, my lord, my respectful submission is page 47. Impugned action has not been taken yet because last part of page 47, it reveals, my lord, that, my lord, he will merely examine. And, my lord, in fact, the petitioner has been allowed to continue. Status quo is on. So
There is no-
action.
There is no scope for examination once it is democratically elected.
Yes, yes.
That is the end of it. That's
That
what
is
this
correct,
title
my lord.
says.
Yes. If he is not removed, my lord. Yes, correct, my lord.
You can't, because it displeases you, you
Yes.
can't.
In fact, my lord, as it appears, the assistant registrar is reading between the lines, my lord. Expressly not provided.
It hurt Mr. A. Bhuiya, learned counsel, assisted by Mr. A. Akriya, counsel for the petitioner, as also Mr. Talukdar appearing for.
I'm for 1 minute.
Mr. Das for respondent one.
Only one.
Only one. Mr. Talukdar for
2, 3, 4, my lord. 2, 3, and 4. 5, my lord. Notice has to go, my lord.
The petitioner is agreed by the impugned. Communication dated 19/1/2026, issued by the Eastern Registrar Cooperative Societies, Kamrup, whereby the no confidence, whereby the resolution adopted in the no confidence motion brought against the petitioner in his capacity as the president of Pub Chamaria Gram Panchayat Samobai Samiti Limited, Umar, and which was defeated in the face of lack of the resolution being passed by 3/4 majority. The respondent authority has refused to accept the said resolution adopted and had instead called for re-examination of the papers in view of the fact that the president, in view of the fact that the petitioner, who was the president and against whom the no confidence motion was brought, had also voted in the said no confidence motion. Stop. According to the Eastern Registrar, such act is contrary to the basic rules of natural justice, as the person against whom the no confidence motion is brought ought not to have voted in the said proceedings. Stop. Mr. Bhuiyan, referring to section 36 of the Assam Cooperative Societies Act 2007 submits that in respect of no confidence motion, the resolution is to be passed by 3/4 majority of the directors present and voting at a meeting held for the purpose for removal of the president or the vice president. And such meeting shall not be presided over by the president or the vice president against whom such a resolution is to be considered. So Mr. Bhuiyan therefore submits that in the facts of the present case, the petitioner, who was the president of so-and-so Gram Panchayat, against whom the no confidence motion was brought, did not preside over the meeting. Instead, the who had presided?
Page 39, my lord. Trilakya Ranjan Deka, Senior Accountant Officer in compliance of order dated so and so. It's a registered order.
One Sri Trilakya Ranjan Deka, who is the Senior Accounts Officer / Auditor under the Cooperative Societies Department, was directed to preside over the said meeting, and the same was accordingly done. Stop. The resolution adopted in the meeting held that the resolution of no confidence motion, the proceedings of no confidence motion against the petitioner could not be passed in the absence of the resolution being adopted by 3/4 majority of the directors present, and therefore the same was defeated. Stop. Accordingly, the president, the petitioner as the president is now required to be permitted to continue his functions. Stop. However, by the impugned order dated so and so, the Assistant Registrar of Cooperative Societies has refused to accept the resolution adopted and was instead called for examination of the entire proceedings, but in the meantime permitted the petitioner to continue as the president. Being agreed, the present petition is filed. Mr. Talukdar, appearing of the respondents, Talukdar and Mr. Das, appearing of the respondents, submits that instructions would be necessary in the matter. So, prima facie, upon the perusal of the provisions of section 36(4), it appears that the bar, expressed bar under the statute is in respect of the president or the vice president presiding over a meeting, call for no confidence motion of such president or vice president. So there is no express bar for casting a vote by the person concerned in a meeting or a motion brought against the said president or the vice president for no confidence motion. Stop. The said resolution of no confidence is again required to be accepted by 3/4 majority, and which has been done as per the resolution recorded, and as is also, is it reflected in the impugned order also?
Yes,
Is it reflected that 3/4 majority?
that is not been there, my lord.
However, the impugned communication dated so and so has expressed has not accepted the resolution adopted by the directors
It was said on the
in this
respective
meeting
majority of 3/4 shall be completed.
on the ground that the president that the petitioner as the president ought not to have been present in the meeting and voted. Ought not to have been present in the meeting and ought not to have cast his vote. Stop. This court is of the view that prima facie section 36(4) or any other provision does not specifically debar the concerned president or the vice president to be present in a meeting and cast his votes. Stop. There is also no doubt, there is also no dispute that resolution was adopted by 3/4 majority in favor of the petitioner. Under such circumstances, this court is of the view at this stage, the notice be issued returnable for which, since the respondents 1 to 4 are represented, notices are waived, extra copies be furnished within a period of 1 week from today. Steps on respondent 5 by registered post within 1 week from today. Till the next date fixed, the impugned order dated so and so shall remain stayed, and the petitioner will be permitted to perform his function as the president of so and so.
Deeply obliged, deeply obliged. Thank you. Definitely.
So the petitioners are landholders. Petitioner number 1 is a landholder, 3 is a son, his son, having all transferable and heritable rights. Now, holding a Miyadi Patta land. Now at page 31, an impugned notice under section 165 have been issued, giving us 15 days time to give the necessary documents and 1 month's time otherwise, Lordship, for vacation. The same notice.
Yes, it is in a tribal belt.
Yes, Lordship, it's a, whether it is notified tribal belt or not, I have no instruction on that. Lordship, but Lordship, we are landholders, not settlement holders. 165, Lordship, 165 applies to settlement holders. And therefore, Lordship, we are occupying the land from our forefathers, Lordship. We have annexed an annual patta at page 40 of 1936. Our names have been recorded in the record of rights and Jamabandi.
Page number?
Page 20 from 19 is the Jamabandi copies. Page 40 is the earliest patta, Lordship. 42 is the original annexation. It's of 1936, the page 42 document. Otherwise, petitioner number 1's name is there in the Jamabandi also.
Yes, Mr. Sharma.
Lordship, if your Lordship comes to the page 33, the vernacular one notice, It is only a so-called notice. What prevented them from submitting the documents?
No, we have already submitted the documents, but they are not withdrawing the same till now.
No order has been passed.
Then
No order has
Lordship,
been passed.
let the direction be given. Thereafter, Lordship, the right arises to approve this honorable court. The direction
My
may be
1
given,
month
Lordship.
completes on 31st, Lordship, that's all, tomorrow.
Till then, Lordship, no coercive action. Let there be a
Lordship, one thing I wanted to show, Lordship, at 164, the rights of landholders is given. 165 applies to settlement holders only. Therefore, this notice itself is without jurisdiction.
But my learned friend has not annexed anything that they have submitted the document before
Page
the.
12, we have pleaded.
Learned
Para 12.
Mr. Rohit Sharma, additional senior advocate for the state. Petitioners claim to be landholders. In the
Para
village
12
of
is a matter of knowledge, Lordship. It's not a matter of record.
Sharai Hagi, Moza Mills, Tetelia, lot number 7, Morigaon Revenue Circle District, Morigaon. Stop. Petitioners claim to be landholders since their forefathers as far back as 1936. Stop.
Gandhi Rally.
They have been given annual pattas. You are given what?
Lordship petition, we have, our names have been entered at page 19 by way of inheritance, Lordship. Page 19.
The petitioners' names have been entered in the Jamavati by way of inheritance.
Page
By way
19,
of
Lordship.
inheritance. It is the claim of the petitioners that notwithstanding that, the respondent authorities have issued. Where is the notice?
Page 31, Lordship.
Vernacular 33.
Particular 33.
Issued.
3 notices are there.
Huh?
3 petitioners are there, therefore 3 notices.
Have been issued individual notices by notice dated 31/12/2025, whereby they have been asked to produce their necessary documents for asserting their land rights in the tribal belt. Stop. Pursuant to the said notices being issued, petitioners duly submitted their documents when?
Documents, Lordship, within the stipulated time.
Within the stipulated time prescribed. However, no orders have been passed. And the petitioners are apprehending that tomorrow being the last date prescribed in the notice, Now, why are you saying it is last date tomorrow?
31/12, Lordship, it was issued on 31/12.
Then within 15 days only.
Now, within 15 days, we have to give the documents, and within further 1 month time, we are stated to be vacate the land, Lordship. Lordship would see.
1 month time will not expire on tomorrow.
Lordship, page 32. Therefore, notice is hereby issued to submit the necessary documents and proof for asserting land rights in the tribal belt within next 15 days, as per section 165. Proof of eligibility for land rights of the tribe can be submitted to the office of the circle officer of the revenue circle. Otherwise, you are directed to remove the house, shop, crop, fence on the shed within 1 month of the receipt of this notice.
That's right. So this 1 month will be after 15 days only.
Yes, that is.
The petitioners submit that the notices are issued under section 165 of the revenue regulations, which is not applicable to the landholders. The said provision is applicable only to the settlement holders. Stop. Being agreed, present writ petition is filed. Mr. H. Sharma, what do you say?
Lordship,
Subject
my,
that this
my
is
contention is that Lordship, they have been given the time to submit the documents, but they did not, Lordship.
Opportunity has been given to furnish the necessary documents. And which, if the petitioners have submitted, then appropriate orders will be passed by the authorities.
Lordship.
In that view of the matter, we direct this matter to be listed again on 20 February. Or shorter date,
It can be shorter, Lordship.
13th. By-
1-3,
1-3.
Lordship.
By which date the respondents will apprise the court as to whether any orders have been passed on the objections, documents, etc. filed by the petitioners pursuant to the Indian notice dated so and so. List again on 20. Till the next date fixed, no coercive action be taken against the writ petitioners. Extra copies be furnished to the learned counsel within 2 working days. MSPR Monto was 1. Mr. Das.
No, sir, 2 to 4.
Okay. Mr. Arun Das, you are appearing in the matter? Okay.
Lordship,
That's only for never to be available. Yes.
I'm appearing in item number 55. So, Lordship, yesterday evening only we have received the copy. May I pray that let this matter be come up on Monday, Lordship?
What is this item?
Eviction, Lordship.
No. This is item 53.
53. No, I am praying for item 55. Lordship.
50.
Delivery of judgment WBC 5
We have rejected the contentions of the writ petitioners with a claim of pension. However, in view of the recent judgments of the apex court in Sripal and Jaggo and all the others, we are molding the relief by directing the respondent authorities to examine whether these employees who have put in consistent years of age can be granted any financial benefit in lieu of pension. For
In
which,
terms of the judgment, Your Lordship. In terms of the judgment by the Supreme Court.
not in terms, in view of the various judgments being offered, being issued by the Supreme Court.
Yes, Your Lordship.
Now, the committee will be constituted by the Chief Secretary, comprising of Additional Chief Secretary and other competent officers from Finance, Works Department, Personnel and Department of Law. Committee will examine modalities and formulate a scheme. The reason being, the question of grant of pension to work charge and muster roll has already been held to be negated by division bench order, and which has attained finality. To that extent, we are molding the relief.
Oblige, Your Lordship.
Disposed.
item 50.
Yes.
My instructions are that no decision has been taken. If such decision is taken at the future stage, then the directions passed in WF 251 will be complied with.
251.
251. Then it would not be signed.
No decision. Mr. Mazumdar, no decision has been taken.
Further, respondent has visited the place of the petitioner.
This is their instructions.
Yes,
We'll
sir.
record it.
Lordship.
This is by the divisional forest officer.
Lordship.
Heard counsel for parties. This writ petition is filed by the petitioner. Petitioners who claim to be allotment holders, settlement holders, or legal heirs or next of kin of allotment holders, settlement holders in village Sonapur, Moza, Purbo, Butu, Chera under Revenue Circle, Ramkishan Nagar, ES Rathabari, District Sribhumi, Assam. Petitioners claim to have been residing in these lands from several decades in the past. Stop. The petitioners are aggrieved that the forest officials visited the areas of the areas where the petitioners are residing and have intimated them that they should vacate these land which are within the forest areas, and failing which they shall be forcibly evicted. Any notice issued? No notice. However, no notice as such was issued. Being apprehending action, the petitioners have approached this court. When the matter was called up today in the morning, the Standing Counsel, Forest Department, Mr. KP Pathak, was permitted to obtain his instructions, if possible, during the course of the day. Stopped. The matter was again called up in the second half, whereupon Mr. Pathak has placed before this court the written instructions issued by the Divisional Forest Officer, Karimganj Forest, within bracket T, Division, Sribhumi, that no decision or date has been fixed to conduct any eviction exercise in the Singla Reserve Forest. Stop. If any decision is taken at a later date, then the procedure, safeguards and directions laid down by the Honorable Division Bench of the Guwahati High Court in judgment dated 18/8/2025, passed in writ appeal number 251 of 2025, shall be strictly complied with. Stop. This being the written instruction received from the respondents, at this stage, this court is of the view that the writ petition can be closed, directing the respondents to strictly abide by the guidelines and the procedure and safeguards laid down by the Honorable Division Bench in writ appeal number 251 of 2025, dated by the order dated 18/8/2025. Writ petition accordingly stands disposed. Lal, do you have a copy of the petition with you?
Yes.
I think 55.
Lordship, in this matter, I am praying for some time, Lordship. That is, this matter come up on Monday, Lordship.
Monday.
My Lord, can you see? These persons were occupying those lands since independence. Now, they have issued notice directly for eviction. Without by violating the guideline issued by the Honorable Supreme Court. Let the that time I have no objection. No coercive action in the taken by law.
Monday or Wednesday?
Lordship,
It may be
Monday I can.
it may be 6, my lord.
Because yesterday evening only we have received, I have received the copy, Lord.
All right, counsel for the petitioner. Submits
violation of
that
the Honorable Supreme Court
petitioners
jurisdiction.
apprehend eviction by the respondent authorities from the land under their occupation. Mr. R.M. Das, learned counsel, appearing for water resources.
Water resources.
Submits that he would like to obtain instructions in the matter and submits that the matter be listed on 2nd,
Lordship.
by which date he will obtain his instructions. Mr. N. Das, appearing for the government, for the state, makes a similar prayer. Accordingly, matter be listed on 2nd of February. Meanwhile, till 2nd February, no coercive action be initiated against the
15 days,
petitioner.
notice says 15 days time. It is yet to.
It is notice.
Pursuant to the notice dated so and so. What is notice is that page number?
Page number,
Annexure 2,
142,
62, page 62.
131,
page 62 from onwards.
60.
62. Huh? It's page 62. Yes. It will marry the Monday.
It is for order 1323.
It is hearing completely lordship.
So again, the hearing,
Huh?
hearing completed. already.
Oh, this matter.
Yes, Lordship. So,
We'll keep it on 7th. The 7th is a working day.
okay.
So we'll keep it and dictate the judgment on 7th.
Yes, Lordship.
All right?
Okay.
Matter be listed on 7th as the hearing has been concluded. Attempt will be made to dispose of the matter on the next date fixed.
Okay.
Wrong, I say. Yes. Oh, not very recommended.
Matter becomes infructuous, my lord. It related to election of, Panchayat election of 2018.
Related to?
Related to, my lord, no confidence motion in respect of,
None appears, we don't know.
none appears, my.
None appears for the petitioner on call. None had appeared for the petitioner on call when the matter was called on 9/12/2020. It appears that the petitioner is not interested in pursuing the matter. Accordingly, the same stands dismissed for non-prosecution. Interim orders, if any, stand vacated. Pending IAs are also dismissed. Mr. S. Dr. for PNRD Department. PNRD, MS M. Bormon for
2 and 3.
respondents 2 and 3.
Hello.
Lordship, in the I have to file an affidavit. I will file it by today. Give me some time, Lordship.
You are for the applicant.
Yeah.
Counsel for the applicant prays for 2 weeks' time to file affidavit. Prayer made is allowed. List again after 2 weeks. Mr.
I am S. Upadhyay, appearing on behalf of NN Upadhyay, ma'am. I am for the writ petition.
Appears for the writ petitioner.
Deeply obliged.
Obliged, highly obliged.
Mr. R.K. Mohanro for respondent 8, MSG Bora for respondent 5, M. Bormon
State
for
respondents. State
state
respondents.
respondents. G. Hazarika for 1. MS PP Das for respondent number 7. Yes.
28.
May it please the Lordship. My lord, as per office note dated, my lord, 11/11/2025, the service upon the respondents have written but with an endorsement that it is
Insufficient.
addressed.
Take fresh steps.
My lord, I'll take first step, my lord, and may I just pray for giving us a liberty to also take by way of trustee, my lord.
As per office note dated 11/11/25, steps on respondent number 1, 2, and 3 have been received back in the office with the postal endorsement within quotes. Insufficient, address quotes closed. So petitioner is therefore permitted to take fresh steps at the correct address within 1 week from today. Stop. Dusty is also permitted. Routed through the registry of the office. List this matter again after 4 weeks.
I'm highly obliged.
This matter, your lordship, yet government instruction is yet to be provided. What happened in this case?
What is the IA for?
IA we have filed, I am coming to this, your lordship. For modification of the schedule, what we have placed the time of filing of the writ petition, that is, we have stated to be a DAF's part of government fast land. So cases that your lordships, that petitioners are the local resident of, along with the respondent number 8 of Kalinagar part 3. So they have submitted 3 applications, 1 complaint and 2 applications praying for local inspection before the respondent authorities. Petitioners are agreed by non-consideration of those applications, filed this writ petition. Now, what happened in this case? There's a dike named Bakri Hawar Dike in that area that has been made lordship encroachment free in compliance of the orders passed by
No,
the
today it has come for the
the
IA lordship. The IA.
They have filed IA to bring, to submit
Any
an amended
objections?
modified schedule.
Any objections?
Lordship, they have not filed any amendment application. Amendment is not allowed, but this is to
Modified
submit
schedule.
an amendment,
particular.
modified schedule. They need to file an amendment application to, when, to amend the writ petition.
We have not prayed for amendment of the writ petition actually. So our updated schedule you want to provide in the writ petition.
It
As
is
a
also amended, my lord.
Amendment.
You'll have to file a proper application. Moreover, my lord, I got the instruction. Again, the schedule, if schedule is amended, my lord, new instruction will have to come with regard to the new amended schedule.
Where is the amended schedule here?
That amended schedule is
Is-
not provided, but lordship, in my application, my prayer is that
Proposed amendment is not there, my lord.
Schedule is there at
Include
page 8 of
the
the IA.
balance.
Lordship. Page 8 of the IA, they have given a schedule.
we wanted to produce a modified schedule actually, your lord.
New
Yes.
log numbers.
What is the meaning of modified schedule means?
Our-
Whatever schedule you have given
Yes.
is not correct.
No, lordship, it is correct.
Then
But subsequently, because as we are not getting any assistance from the respondent side, we have came to our knowledge that certain ducts that is mentioned in para 5 of the IA may form part of the Gulf Khas land.
so therefore you have to file amendment. They're right there.
Okay, I will file then.
You file your amendment petition.
Amended writ petition, your lord.
No, you have to file an application seeking amendment first. I don't know whether this IA can be converted into application, but
No, prayer is
not
different.
structured that way.
No, sir, proposed amendment it should be there, my lord. At which
You
para, what
will
will
have
be
to bring
added?
a proper application for amendment,
Lord,
seeking amendment.
But my submission is that this is based on our presumption, because as we are no local inspection has been done on 6/1/2025,
See,
officials.
whatever materials are there in the writ petition, if there is something more you want to add, which is contrary to what was there at the time of filing, and it requires certain averments to be made or changes of the averments made in the writ petition, it will amount to amendment.
I do know that, your lord.
Then
Much obliged, I will do that.
counsel for the petitioner seeks liberty of the court to file an amended petition, application for amendment. In that view of the matter, IA number 1857 stands dismissed as not pressed. Matter be listed after 4 weeks, enabling the petitioner to file the amended writ petition.
Much obliged.
May I please, your lordship? Lordship, here service is already completely made. Subject matter of the petition is very small. Methodology is this
বন্ধ করে দিও।
service is complete, lordship, in respect of all the respondents.
Then let it come for admission, notice issued.
The issue is, lordship, my account, the business account has been put on debit freeze back. Only one amount of 2,000 has entered my account through Google Pay, lordship. This is petrol pump, lordship.
Who is representing the other side?
I am representing your, my lordship, 1, 2, 3.
What a bank.
So, our point is that we also are in favor of a withdrawal of this whole actually, my lord. Because this is actually what happens where someone files a case in some police station, it sets a trigger effect and the entire account is locked. However, the petitioner, they're a very valued customer of our client and their loan has slipped into NPA because of the fact that they're not been able to use their account. Because of a hold of just 2,000 rupees alleged irregularity. So our submission, if your lordship takes into account of this and
On what basis have you frozen the account?
there was an instruction from a police station from Trichur. That we were-
29, page 29.
Page 29, where we're directed to freeze the whole account.
You have to make them a party.
Yes, we have already been made party, lordship.
Huh?
And even notice is served upon that police station also, lordship.
Is it?
Yes, lordship. Lordship will see the office note dated, lordship, 11/12/25 and 28/1/26. lordship.
Subsequently, you have amended the petition,
No, only the cost title, lordship.
post title.
Yes. Initially, we have not made them party, but subsequently we made party and we send notice also.
Okay. As per office note dated 11/12/2025, service on the respondent had been completed. Mr.
J. Borua, my lord.
J. Burua.
For one.
appears on behalf of respondent number 123. None represents on behalf of the respondent number 4. Stop. The petitioner is aggrieved that by virtue of the instruction issued by the respondent number 4, by communication dated, where is that communication?
29, page 29.
Communication dated 13/3/2025. In connection
That
but
account.
here the transaction amount is
No,
1,06,000.
That Lordship will come to pay annexure 7, page 28, Lordship. That is the letter by which that it was put on.
The respondent 4 by communication dated 13/3/2025 issued to the State Bank of India intimated that on the basis of a complaint received, an amount of rupees 1,06,376 was shown to be transacted on 5/2/2025 . No, sorry, I get you. Respondent 4 by communication dated so and so informed the SBI that on a complaint lodged by one Mr. M.P. Nandakumar regarding an online scam, the victim lost an amount of rupees 56,23,067.60, and the fraud, and they said money, as per information, was transferred to the account number which is mentioned below in the said communication. Stop. The said account number, namely 40166531467, IFSC code number so and so, is the account belonging to the writ petitioner. In terms of the said communication, the SBI authorities by communication dated 29/3/2025 informed the petitioner that his account has been freezed. In the said communication, there is a mention that a transaction amount of rupees 2,000 was credited to the account through the Google Pay settlement on 20/02/2025. But this letter at 29, it says that this entire amount has been transferred to your account.
No, Lordship.
That's what the letter says.
My-
56 lakhs.
My account is in the name of the petrol pump, Lordship. And
Whatever it may be, but it says it has been transmitted to the said account number.
so no such amount has been.
Mr. Borua?
My lord, what my client have instructed me is that an amount of 2,000 was credited into their account through a GPay mode of payment.
No, from your inquiry or verification, is it correct that the amount of 56,000 lakhs?
No, Your Honor.
No, correct.
No.
Have you enclosed any bank statement?
Yes.
Bank statement is there.
Yes. It starts from page 34, Lordship. It's 1st of February 25 up to, Lordship, 14 March 25.
The learned counsel for the petitioner, referring to the bank statement enclosed to the petition, submits that no such amount has been transferred to the account of the writ petitioner. Rather, this account is being used by the petitioner to run his business of a petrol pump. And because of the account being freezed, the regular EMIs could not be deposited, and his loan account has been shown as NPA by the bank. Stop. Insofar as the bank authorities are concerned, the transaction amount as per information of the bank is only rupees 2,000 through Google Pay settlement of rupees 2002/2025. Stop. Learned counsel for the petitioner therefore submits that for a sum of rupees 2,000, his entire bank account ought not to have been freezed, and he should be permitted to operate the bank account, which is used as a business account. Counsel for the bank also submits that as per their inquiry, no such transaction has been found in the relating to the bank account of the writ petitioner, save and except rupees 2,000, as mentioned in the communication dated so and so. And under such circumstances, this court is of the view that the bank should be allowed to keep a lien of over rupees 10,000. And after that, the account should be permitted to be used. It is made clear that the amount of rupees 10,000 shall not be permitted to be withdrawn from the bank account. What is the minimum balance required to be maintained?
There is no as minimum in the CC account, my lord, there is no as concept of a minimum balance.
I have obliged.
Dispatch.
No, please, Lordship. I filed the handle.
Huh?
I, Lordship.
Huh?
The I for implement of your officer in charge, Dhemaji Police Station and the CID Police Lordship.
Any objection?
No objection, Lordship. In fact, they are required.
Okay. The council, is it pursuant to an order of the court?
Lordship.
Is there any order of the court?
Lordship.
Where is that order?
It's ordered at 25/9, Lordship. 25/9/24.
By order dated 2024, passed in WPC 5541 of 2023, a coordinate bench directed as under. It order extractorily. 25/9/24. In deference to the directions contained in the said order, the writ petition, the IA has been filed, and IA has been filed seeking implement of the state of Assam and Dhemaji Police Station and CID Assam as party respondents in the state application. Considering the directions issued by this court by the order dated so and so, the prayer made in these ayes stands allowed. State of Assam, represented by the Commissioner and Secretary, Department of Home, the Superintendent of Police, the Director General of Police, Assam, Superintendent of Police, CID, Officer in charge, Dhemaji Police Station, are arrayed as party respondents 4, 5, 6, and 7. The petitioner will file amended post title before the registry within 1 week from today. Matter stands disposed of. Registry will list this matter after the petitioner files corrected / amended post title. Disposed.
What's your best?
Highest stands disposed. Writ petition listed after 4 weeks.
Public.
May it please your lordship. Lordship, in this case, we have taken a step upon respondent number 5.
My lord, I appear for respondent number 5.
You are appearing.
I am, my lord, I have instructions to concede, provided if your lordship will kindly allow me to point out one small thing. If your lordship would kindly take up your lordship's order on 9/1/2026. What has happened is the election tribunal has directed the district commissioners to bring all the ballot papers in sealed trunks for counting purposes. Now, the petitioner tried to project it in a manner that this is an interim order, and on the very next day, the ballot papers will be counted. But that is not so. If we once again go to the interim order. So if your lordship disposes of this matter with an observation that the ballot papers may be counted after the end of the trial, or his prayer is once the maintainability of the election petition is decided. So once with that observation, if this matter is disposed of.
What is the interim order here?
Well, the interim order is your
Well,
lordship
in state.
statement.
State.
State. So the next date fixed was for production of the ballot papers. But the order, if your lordship kindly come once to the impure order, sir, page 70.
Page?
70. 70 it starts, page 71, the last paragraph. The last paragraph, page 71. Hence, the District Commissioner Gwalpara is directed to produce the ballot papers of the election of GP member of Unit 8 of Garogajan Ko, Timlabari GP, before this court under sealed trunks to facilitate this court for recounting of votes on or before the next date. Now, he tried to project it in a manner that the court is going to count the ballot papers on the very next date. But the court only directed the district commissioner to produce the ballot papers in sealed trunks on or before the next date. Well, there should have been a comma actually after the word votes. Then it would have made more sense, man. And your lordship will see the last line, for ballot papers, the next date is fixed. So there's not going to be any recounting. His third prayer in the writ petition is.
Why is it for orders today?
My lord, it's for service, man.
Then you appear and say whatever you want to say on the next date.
Well, we'll fix it for admission, man. But kindly fix a date because the trial is statement. And only he will benefit once it gets
Mr. P. Bharadwaj, Learned Counsel, has entered appearance on behalf of respondent 5. Accordingly, service is complete. Matter be listed again on 19.
Madam.
Interim that may be continued.
Interim order passed earlier will continue till the next date.
May it please your lordship. Lordship, we have taken steps on dusty service lordship on respondent 4, 5 and 6. 4 has accepted lordship, but respondent 6 has refused to receive the notice. And
Where is the affidavit?
affidavit yesterday we have filed lordship, on 4 and 6 we have filed.
Yesterday.
Yesterday lordship.
Is not here.
It's not on record lordship.
Counsel for the petitioner submits that steps by Dusty has been taken and an affidavit of compliance has been filed yesterday.
Respondent 5 will take the service.
The same, however, is not connected to the case record. Registry to connect the affidavits filed and list it before the court on the next date. 11th February.
Obliged.
Actually, I'm a petitioner. No, Oh, my lord, my learned friend has filed an IA. That, my lord, this interim order was passed after hearing all the parties. Now, if your lordship would kindly come to order dated 6/11/25.
From the writ petition.
In the writ petition, my lord. Please come to page 3 of the order, my lord. Last para, C. Woodin, Learned Counsel particularly opposed the interim prayer by submitting that in the meantime, present respondent number 5 has instituted a writ petition wherein election of the petitioner has been put to challenge, etc. etc. So he was heard. Then my lord will kindly come to page 4. The subpara, though the issues raised on behalf of respondent number 5, on whom behalf this IA has been filed, would be relevant for final adjudication of the case, Rule 62(1)(f) has prescribed for a particular manner by which a complaint is to be lodged and adjudicated. In the scheme of the rule, election officer does not appear to have any role. In view of all above, till returnable date, order dated passed by this shall be kept in abeyance. So, my lord, let them file their affidavit. Lordship will keep it for admission for disposal. And another point I would like to highlight, my lord. Now, the issue is, my lord, whether the present petitioner before lordship, he has more than 2 child on from the cutoff date. Cutoff date is, my lord, 19/3/2018. Because this amendment came on 31/10/18, but it was given retrospective effect from 19/3/18. And my lord, the issue is, but the petitioner's wife conceived prior to 19/3/18. Precisely same issue is, my lord, Supreme Court is in session of the matter in this SLP. So
Still
therefore,
pending?
what same issue, my lord, where notice has been issued.
Prior to the.
Yes,
notification.
yes. Now, my lord, admittedly, Act came into force on 19/3.
What
And
is the provision in the act?
provision in the Act, my lord, if your lordship would kindly have the Act for a moment.
Yes. Panchayat.
Section 111.
Kali ulai gelo.
এখন দি দিয়া না।
ভালো রাখে।
বহু কিতাপ নহয় নেকি এখন?
Page 118, if this is the book.
মোৰখন ক'ত? নহয় নহয়, মোৰখন
এটা আগৰ নাকি?
111.
This is old one.
No, look, 111.
No, the book maybe,
This one.
yes, section 111,
111.
amended person.
আছে আছে আছে।
No, তাতে আছে।
No person shall be elected, subsection 2, my lord.
No, this is not available here. I think. Oh, it is here.
Yes. No person shall be elected or co-opted and remain as president, vice president, or member of a Jila Parishad, Anchalik Panchayat and Gaon Panchayat, who has more than 2 living children from a single or multiple marriage. Now, this is important. Provided that this provision shall not be applicable in respect of those persons who have more than 2 children prior to the date of commencement is of this Act. So, my lord, whether this would also include a person who has conceived. So that is the issue which Supreme Court is in session of now, presently. Now, there is no dispute that on the date I was not having, of course having, but the conception took place, my lord, prior to 19/3/18, because the child was born on 10/10/2018.
This amendment was brought on.
31/10/18, my lord. But it was given retrospective effect from 19/3/18. And the third child was born on, my lord, 10/10/2018. So if it was on 10/10/2018, going by the, my lord, medical concept, my lord, more than 9 months. So therefore, on 19/3/18, prior to that, she conceived. So when the Act did not come into force, on that date, that stipulation was not there. Therefore, my lord, Supreme Court is trying to give a meaning to that proviso. Proviso says one who has got more than 2 children before the date of coming into force of the Act will not be applicable. Now, whether it will be applicable in a case where conception took place prior to the coming into force of the Act.
This is that Haryana matter which is being reconsidered.
Yes. And my lord, if we go by the contemporary decisions of the Honorable Supreme Court, it is always given effect to post the, my lord, the events taking place post the coming into force of the Act. I brought 2-3 judgments on that line. And this will require some amount of hearing, my lord. And secondly, my lord, subject to what my learned friend may say, since the Supreme Court is in session of the matter, we may perhaps wait for about 4 weeks, my lord.
Thank you, sir.
Okay.
Actually, this file by me, my IA, Supreme Court continuation of delay is pending, madam. That was confirmed. My case is somewhere else. Madam, my case is because already it is decided.
You're filing vacation of the interim order.
Yes. Now, my case is madam, already decided by this court that he is having 3 children, madam, more than one. And that was not chilling. This is my case somewhere else, madam. Already he has been already declared by this honorable court. I take to your lordship that the paragraph, my lord, they themselves have stated, my lord, your lordship will find. Kindly see, my lord.
No, but here, the whatever way, interim order, all these issues were not raised. While granting the interim order?
No, interim order, your lordship,
Yes, it was
till
raised.
honorable date, it was open, madam. Interim order says.
But after hearing you.
Yes. No, that is there, madam. That I'm not saying, madam.
Then
but-
why the vacating now?
No, vacating because there's some new fact which has not been there, madam, in the writ petition, my lord. It is on the day of motion, my lord. We did not get chance to, my lord, file that here, my lord. So whole question, my lord, that matter already decided by this honorable court that he is having 3 children, he is disqualified. That was, madam, upheld by this honorable court. That was not annexed before this honorable court, my lord. There might have been not what, but they say they did not have knowledge. I take your lordship to only one, my lord. Your lordship kindly see that 26, my lord, page, your 64, my lord. No, 64, my lord. The High Court's order, the idea of the 27/6/25. Huh? In IA. The page photo.
Yes, 15.
Hmm?
15.
Yes. Page 15 in IA, my lord. Page 15, your lordship in part is page.
29.
Yes.
29.
Page 29 condition.
29 of?
Page 29 of IA.
IA. Yes.
What happened, my lord? Idea he was a member of the Anchalik Panchayat in the last term. So kindly, my lord, check out history, my lord. Idea he got, my lord, he was a member of the Anchalik Panchayat. So a notice was filed, complaint was filed having that he is having 3 children.
39.
So that was challenged by him. Now you'll kindly see page 29, paragraph 4.6.
Page 29.
You'll also got it, man. 4.6. Page 29, paragraph 4.6. WBC number 229, you'll also kind of 20 in the last Panchayat term. Joinarabad University State of Assam, the petitioner contested for the post of member of Chapok So-and-so Anchalik Panchayat in the Panchayat election held in the month of December 18. As on 19/3/18, the petitioner had 7 numbers of children and he was eligible in terms of the then extant provision of the Panchayat Act and rules. It was on 18/11/18, he became the father of another child. You'll also kindly note, madam. A complaint was thereafter lodged on 13/11/19 by some complainant, including respondent number 7 and 8. Before the Deputy Commissioner Dubri seeking removal of the petitioner from the post of member of Anchal Panchayat from so-and-so. On the ground that the petitioner became disqualified in view of the fact that another child was born to him after 19/3/18. The Deputy Commissioner Dubri, upon receipt of the said complaint, instructed the sub-division officer to take necessary action, forward the complaint to the concerned BDO, then take necessary action after proper verification. An inquiry report was prepared and submitted. Based on the finding in the said inquiry report, the block development officer recommended removal of the petitioner. The present petitioner was the petitioner, my lord. The subdivision officer had thereafter wrote to the CEO on 27/1/20, recommending the removal of the petitioner from the post of member of Anchalik Panchayat from so-and-so. Agreed thereby, the petitioner has approved this honorable court by the writ petition against the recommendation for his removal and for direction of the respondent authority not to act upon the said and to allow the petitioner to function as AP. Now that was decided, my lord.
Yes.
That petition was dismissed on finding that he is having 3 children, my lord.
50.
Page
49, 50.
Page 49, you can see 49 last, my lord. 30, paragraph 30, my. Page 49, paragraph 30.
it may be stated that the cost of reputation that in all this reputation, it is not in dispute that the incident, the birth of the child, or beyond to member of the child desirous of becoming a member of the Panchayat students, the case may have occurred after the date, that is 19/3/18. The process of a removal of concerned member in the writ petition, W number so and so, 2279 is the present petition of my lord, 2279. On the ground of incurring disqualification under section 112A of the Panchayat Act has been initiated and has been completed by following the due procedure laid down in the so and so, so and so. In view of the discussion made there for the reason, the court does not find any merit in the contention advanced on behalf of the petitioner in this petition. For similar reasons, so and so, so and so is discussed. This was not challenged. And in
So
terms of the,
what was the decision of the coordinate bench?
yes, DC, thereafter DC passed the order, my lord, page 51. Next
No,
page.
No, you are referring to a judgment passed by the coordinate bench. What was the conclusion?
This is the conclusion, my lord, your lordship. Your lordship. Panchayat Tribunal, the contention 29. That is my lord. This is the dismissed, my lord. Incurring disqualification has initiated so and so petitioner of the said for similar reason the writ petition number so and so are found devoid of any merit. As a result, the writ petitions are liable to be dismissed and the same accordingly dismissed. The interim order
Writ petition was filed by?
Filed by this present petitioner, one of the writ petitions. And now they have stated, madam, kindly see paragraph 4 and 5 of their petition, madam. You also kindly see paragraph. What was who? Huh? The statement, this is what it is. Madam, kindly come to page 16 of the writ petition.
16.
Page 16.
16.
Yes.
Yes.
The petitioner begs to state the petitioner challenging the aforementioned letter number 27-2.
You are reading from 16:16.
Paragraph 16, madam, better to page 220, madam, page 15, madam, kindly. Page 215 of the writ petition.
I have not.
Writ petition, madam.
Writ petition, page number?
Page number 1516.
15. 15 is post title.
No. Writ petition, madam. Para 20.
Okay. Yes.
The petitioner begs to state that it is important to mention here that the petitioner contested the Panchayat election in 2018, the last term, as Anchuri Panchayat member. The election was held and the petitioner was elected as a P member. Thereafter, a complaint dated 18/11/19 was lodged before the DC Dhubri in regard to the status of the children. ADC Dhubri by data number so and so Bilasipara to take necessary steps as per amended provision dated 19/3/18. Thereafter, an inquiry report dated so and so was submitted by the secretary of the so and so, wherein the secretary clearly stated that the last pregnancy date found on so and so 14/2/18, and he is in confusion in respect of the legality or illegality as per the amendment of the Panchayat Act. Shockingly, the SDO Bilasipara by his letter dated so and so 27/2/20 informed that so this is under chilling, madam.
You take your seat, please. Pani and Ani overall one ani no to gaya. Huh? There ki emergency dana lagi.
Sign to bear na.
Sign to lagi.
Case ka sign to bear na phala.
Are you all right?
I think so.
My friend was asking me whether it is an ominous sign for the case. I said the sign for the case is stopped today.
My lord, yeah, I'm strong enough. Shockingly, the SDO Bilasipaka by letter so and so dated 27/2/20 informed the CEO by letter recommended for removal of the petitioner from the concerned AP member. So this was under challenge the reputation which your lordship is just now saying. This. The petitioner was not aware of any kind of inquiry carried by the SDO, suppose so and so. Then paragraph 21. Petitioner begs to state the petitioner challenged the aforementioned letter number 27/2/20 before the Honorable High Court by WC number so and so. During the adjudication of the case, few other cases are also filed, and all these cases, total 9 numbers were taken together. It is important to mention here that one exactly similar case, WC number so and so, Jahanagar, that Supreme Court they are saying about that, my lord, was also taken together in the said case. The cases are heard together on 7/12/21, and all the cases are dismissed by judgment written so and so. While deciding the case, the Honorable Court did not deal with the issue as to what will happen if the woman was already conceived. The Honorable Court in paragraph 30 of the judgment simply went to the fact that third child was born after the so and so. The petitioner, that is important, my lord. The petitioner was not aware of the said judgment and continued his office as a member till the last day of the last term. This is the position. I am only on this point, my lord. He was not aware. He was the petitioner of that case, my lord. He himself was the petitioner of the case. And now that remained unchallenged, my lord, till today. Can it be open now whether it is maintainable the present petition, my lord? They said they are not aware, my lord, how it can be. They contested, after the contest case was, my lord, this order was passed. So that theory of estoppel comes, my lord.
Yes. There appears to be some finding by the court.
No, my lord, I'll come to that.
But-
My lord, first of all, there is no suppression. We have mentioned
straight.
everything. No, I'm
Not
saying,
properly
yes,
instructed.
yes. What I'm saying is, my lord, now this was for the earlier term. This was for the term, my lord, prior to 26. Now, recently the election was held in 2026. Now there is a issue. My lord. Now this is a reason.
Another issue.
No, present issue.
Oh.
Now, my lord, that point, whether if somebody, my lord, my conception, my wife's conceived on 14/2/2018, when the act did not come into effect. That is why, my lord, that Jahanara Begum's case, which is in Supreme Court, now in that case, there was delay has been condoned. I have the order, my lord. Now the question is, all these things were informed to the Honorable Court while passing the impugned order. That's why this Honorable Court said, now what they have urged on that day would be relevant for final call. Now, my lord, if tomorrow Supreme Court decides that the conception is a relevant aspect, then what happens, my lord? So today, yes, for the earlier term, there was a decision. I'm not saying so. But for the present term, the decision is alive. In that view of the matter, my lord, either your lordship decides the matter or lordship waits for about four weeks, because delay has already been condoned on. My lord, delay was condoned on. Could the lord have you? Yes. April 2025, my lord, delay has been condoned in the SLP. The issue notice to the respondent to show cause as to why delay in filing so and so, subject to so and so delay condoned. Notice is hereby returnable on 9/5/25. Liberty is granted petitioner to serve respondents through dusty process. So, my lord, since the Supreme Court is in session, my lord, I am not disputing the position that for the earlier term there is a decision that we have already mentioned very clearly. And I completed my full term. That statement is also absolutely correct. For that order, my lord, it's not that my member as my position as a member of Anchalik Panchayat came to be curtailed. I completed my tenure. Now, if tomorrow, my lord, Supreme Court decides that the act cannot be made applicable in a case where the conception took place prior to 19318, then my lord, my case is otherwise, my lord, very good case. And secondly, my lord, kindly see how Rule 62 was flouted, my lord. My lord, this cannot be done by an election officer. It has to be initiated by the, if your lordship would kindly come to the rules for a moment, my lord. Rule 62. Why this stay
Right,
was
we'll
granted?
continue hearing.
Yes,
On
my lord.
some other date.
Yes, yes.
Will require some amount of
Yes, my lord.
hearing.
Yes.
Mr.
But on the
Chaudhary.
basis of it, my fantasy, I think, madam. Your lordship.
We'll carry on. Only question is whether we should.
I am on
ordinarily-
theory of stopper, madam. I am not on. this.
No, ordinarily, if the issue is decided by the apex court, then it clinches
So
everything.
that matter, how long, your lordship knows, the notice is contained April 2025. It is a question of election of the panchayat, madam.
We don't know how long it will take.
So, no, so there is a problem, madam. So how long? So.
We will have it in the first week of March.
Yes, madam.
March, madam, can it be February, madam? Because
February.
we have also some duty, madam.
Then what, give us a date?
Last week, my
Your
lord.
lordship, madam. If
26th,
possible, middle or last week.
26th of February.
Yes, yes.
Heard counsel for the parties, Mr. H.R.A. Chaudhary by him, assisted by Mr. H. Ali, Mr. K. N. Chaudhary, assisted by Mr. J. Abidim. The Mr. S. Dotto for Panchayat, Mr. Dubey for election, State Election Commission, MS M. Burman for state respondents. The issue presently is pending before the apex court in Jahanara Begum versus so and so. Nevertheless, it will require some examination as to the contention raised by both the parties before the court regarding the applicability of the provisions, amended provisions of the Panchayat Constitution rules. Correct. Is it a Panchayat Act?
Yes.
Section 111. Let this matter be listed again on 26th of February. Interim order, I don't think we have
Yes,
to.
it will have
extend.
to continue, my
We'll
lord.
have to. Interim order passed earlier. Will continue till the next date of listing, 26th. Meanwhile, parties are at liberty to apprise the court as to any such orders that may be passed by the apex court in the meantime.
And we may be also allowed to file affidavit also.
Yes, yes, yes.
Yes.
You want to file?
Yes, madam.
The
No,
parties are also permitted to exchange their pleadings
Yes.
in the matter.
Deep lord.
No affidavit.
Affidavit had been filed yesterday.
Mr. D. Dhaka for the petitioner, Mr. H. Gupta appearing for the respondent submits that affidavit has been filed yesterday. Let this matter be listed again on 13th. By which date the registry will trace out and connect the affidavit stated to be filed by the respondent. This on 13th.
Similar for this next item, 36.
Similar order.
Like it.
All right.
37.
Yes. Revenue anymore, I have seen what it is.
What is the meaning of this?
Lordship, that application now is pending before the nodal officer, my lord. Then it has to come back to the DC again, my lord, after their verification. Then only that, as per new notification of 9/9/2025.
This is for permission.
Permission, my lord. So that round has to be completed, my
How
lord.
long is it? How long will it take?
It is, the nodal officer is represented by the revenue department, my lord.
Who is for the revenue?
I'm.
How long will it take?
That pending is
Counsel for parties, as per instructions received, the learned government advocate MSN M. Borman has informed the court that the issue of land sale permission within bracket NOC submitted by the writ petitioner has been forwarded to the nodal officer and joint secretary revenue and disaster management on 16/12/25. Stop, it is submitted that once the nodal officer completes the scrutiny, the same will be remanded back to the deputy commissioner. Stop. MSG Hazarika, learned counsel for the revenue department, will apprise the court on the next date as to the status of the orders, if any, passed by the nodal officer on the NOC submitted by the writ petitioner. List on 2020.
Just one thing I like to mention, Lordship. Lordship, the time when that application has been made, the time when the application was made, there was no nodal officer. Yet we have made a representation subsequently, Lordship. So representation has been made in the month of June also, Lordship. So it has been almost 6 months.
Let us find out. Let's find out.
Lordship.
We'll just come back in 2 minutes. Yes.
Lordship, the matter of hearing Lordship, the land acquisition. So hearing Lordship, the petitioner land was acquired in the year of 2001, Lordship. Since 2001, Lordship, so not a single penny has been received from the concerned authority, Lordship. The Water Resource Department, Lordship, the Deputy Commissioner of the Dorong, Lordship.
I could not send the notices, my lord. Extra copy have not been provided to me, my lord. Being commented. Notices ready.
Several times I have served, Lordship.
No.
Serve them copies, give them soft copies.
Had I been get the copies immediately, I could have instructed my lord.
Give them
The
copies.
notices in file, my lord. No,
At the time of filing, you have after issuance of notice.
So Lordship, 18/11/2025, Lordship already submitted.
Submitted.
Copy, Lordship.
my notice is there.
All right, serve them one set of soft copies if inconvenient. The had Mr. R.C. Das, counsel for the petitioner.
ইমান নালাগে মোক এটাই লাগে
MS
notice.
M.
Usually পঠিয়াও।
Learned
No point of
government
studying.
advocate submit that instructions could not be obtained as extra copies were not furnished. Mr. Das, on the other end, submits that extra copies were duly furnished, be that as it may. We permit the petitioner to serve extra copies by soft copy if required, or extra copies of the writ petition. Thereafter, the respondent will obtain instructions
After 3 weeks, my.
in the matter. List after
3 weeks, my.
3 weeks.
3 weeks.
Lordship, the
MS
2 weeks, Lordship.
Huh?
So Lordship, all petitioner are the senior
No,
citizens.
no, you first serve the copies, serve copies. 25th
Yes.
February.
Yes. Master.
39.
Chief, in this case, I was supposed to produce the records, Your Lordship. I have received the records. It's regarding the attendance register of
You bring
the.
it on 3rd.
Lordship.
3rd of February.
Lordship.
Letter be listed on 3rd of February. As it is submitted by the counsel for the cooperation department that the records have been received. We are having it on 3rd.
Third.
Mr. S. Bonik for respondents.
456.
456. Third. Huh?
Well, the make clean worship.
Hmm.
I have for the respondent number 8, my lord. I have filed the affidavit, my lord.
Well, here, my lord, we have challenged the selection of respondent number 8 on the ground that my lord, basically, my lord, she has suppressed some information that in the application form number 1, there was no signature, my lord. Application was without signature, and my lord, she has stated that she was a divorcee, my lord. And kindly, my lord, advertisement was issued on 2nd of June 2023, and application last date for a submission of application was 15th of June 2023. And divorce was granted in the year 2025, my lord. They have annexed the, my lord, the judgment of the Honorable Learned Court below. Divorce was filed in the year 2025. So much later than the
Selection.
Yes, my lord. So appointment was made on 19th of November 2024. So at that time, my lord, so there was no case pending, my lord, and that information is the wrong information. And another, my lord, that she has stated that as per
First, tell me how many posts were there? One.
One post, my lord.
That is Anganwadi helper.
Yes, my lord.
Both of you belong to the same area.
My lord, actually, I belong to that area, and her place of birth is the same area. But she got married to a person which is belong to some other area.
And then it was stated that she was divorced, and
Yes.
therefore she has come back to her
Yes.
paternal
Yes.
matrimonial house.
Yes, and certificate issued by the Gaubura is also much later than the selection. They have annexed in their affidavit.
What do the this social empowerment?
Who are made party in the petition, neither copy has been served nor our name has been reflected in the costly theology.
Copy not served.
I have been told by my friend that.
But without serving copy, perhaps at the,
Government.
some other, yes.
It has served copy to the government.
You give copies to, you are representing whom?
I am for social justice and empowerment department.
Social justice and empowerment. That is the nodal department.
Maybe because earlier it's social welfare department, Anganwadi worker is done by the social welfare department. After 2022, it's bifurcated and social justice department has been created. I have to take instruction whether it's done by social justice department or social welfare department.
This is a part-heard matter, therefore either we hear it or we release it.
Lordship, if your lordship fix it next week, lordship, I can subcopy that.
Next week may not be possible, your lordship, because we came to know only today, your lordship.
All right, list on 19th. 19th February, by which date the petitioners will ensure service of extra copies on the Standing Council for Social Justice and Empowerment Department, and attempt will be made to dispose of the matter on the next date fixed.
Name may be reflected.
Names of all councils, including Standing Council, Social Justice and Empowerment, be reflected in the course list.
Obliged.
Right. One aspect I could not submit, because earlier MS Rita Borobora used to appear for a BTC matter. This is a BTC matter.
If BTC lordship, then it's a transferred subject, your lordship. BTC will be the necessary party, your lordship.
Names of council, including BTC council, be reflected. You serve copies on
Yes.
the BTC.
BTC has already submitted their affidavit also.
Obliged, your lordship.
Yes, Mr. Hussain.
My lord, this is for the appointment of arbitrator. In a similar matter, my learned brother appear. So your lordship may pass the similar order.
So why are you giving us an order of 2018? I mean,
No, sorry, my lord, this is the recent order, my lord. No, no. 18. Oh, sorry, sorry. This one. Yeah.
yes, Mr.
Lordship, I have no objection, my lord, but subject to, my lord, the amount of claim is more than 10 lakhs, my lord. Similar, there will be panel of 3, my lord, has with a similar matter, my lord's order.
On one hand, you say no objection, and the other hand, you say
No, my lord, there will be
arbitrators.
panel of 3 arbitrators in case there is an agreement, my lord, in case of more than 10 lakhs, paragraph 16.
So then you say that this order is not applicable.
Yes. No, appointment of arbitrator, I have no objection. Yes. Paragraph 16. my lord.
Yes,
Now,
three
my lord,
arbitrators.
no, my lord, I have objection. My lord, your lordship may kindly come to page 78. Page 78, my lord. Clause number 16.0. Here your lordship may see arbitration and settlement of disputes shall be governed by clause 63, 64 of the conditions of contract NF 1998 edition, which are reproduced below subject to any correction made prior to the opening of this tender. Now, clause number 63. Matters, this is the arbitration clause, my lord. The clause number 64 is the procedure. This is not the arbitration clause. So clause number 63 says, my lord, matters finally determined by the railway, all dispute and differences of any kind whatsoever arising out of or in connection with the contract, whether during the progress of the work or after its completion, and whether before or after the determination of the contract shall be referred to by the contractor to the GM, and the GM shall within 120 days after receipt of the contractor's representation make and notify decision on all matters referred to by the contractor in writing, provided that the matters for which provision has been made in clause 8, 18 and so, general conditions of contract were in any clause of the special conditions of the contract shall be deemed as accepted matters not arbitrable, and the decision of the railway authority thereon shall be final and binding on the contractor, provided further that accepted matters shall stand specifically excluded from the purview of the arbitration clause.
Where does it provide for one sole arbitrator or three arbitrators?
This is the procedure provided under section 64. So in view of the, my lord, the central organization case, my lord, this has become void, invalid.
That is at page 79.
See, if the agreement provides that in case of X amount or beyond that X amount, it shall be an arbitration of three arbitrators.
My
So
lord,
we'll have to abide by that.
no, my lord, I am not, on this respect, my lord, I am making the submission. First of all, my lord, this clause 64 has become invalid. So
why?
Either it can be, I am coming to that, my lord. Either it can be applied wholly or it cannot be applied. Partly we cannot apply this. And in view of the law laid down by the Honorable Supreme Court.
No, what has 64 got to do with it?
Because this is the cost factor matter is there.
64.
64, clause 64.
64
This
one.
is the procedure. Entire clause 64 has become invalid.
Why?
By operation of law.
Why?
Why? Because of the central organization case.
How?
This procedure.
Central organization is only with regard to curated panels.
Yes. Yes. So now the.
Not being appointed without your approval.
No, my lord. Here the clause 64 says the appointment will be made by the general manager and the appointment of the arbitrators.
That has not happened. Therefore, you are here before 11:6 in 11:6.
Yes, my lord.
Hmm.
My humble submission is that this part has become invalid
So,
by the operation of law.
so
So it cannot be taken into account. 64. Either it can taken into account wholly or it cannot be taken into account.
but where is that part with regard to appointment of?
This clause 63. Only clause 63 is applicable. And in this
That is at
respect.
page 79, my lord, what my lord is thinking, my lord, page 79. 64 3A1. In the, from the bottom, my lord, second.
10 lakhs.
Yes, ma'am, second paragraph.
It shall be sole arbitrator.
Yes, ma'am.
Uh,
More than that, my
The
lord,
agreement is that in case of a particular amount, up to particular amount, it will be sole arbitrator. Beyond that, 3 arbitrators.
It means we are accepting the 64.
No, it means that you have agreed that in case of the amount exceeding a particular limit, there has to be 3 arbitrators. You may not accept their curated panel. But
Yes.
that there is no restraint on the court to appoint an arbitrator on their behalf.
Now, my humble submission, as per the law, either we can apply the entire clause.
Then we'll have to hear the matter.
Yes. Or we cannot apply the
Counsel for the
clause.
parties, matter be listed for hearing.
Because cost factor is there. Why I should pay a higher amount to the arbitrators, 3 arbitrators? If the railway is ready to pay the arbitrators fees, then we are ready. This is a government organization.
Of course, railway will have to pay.
My lord, that is why my objection is that the sole arbiter should be appointed.
We'll have to examine.
And your lordship may kindly see the earlier order. This honorable court has appointed the sole arbitrator instead of 3 arbitrators
See,
in view of the Supreme Court judgment.
my lord, judgment at paragraph 16, which I have pointed out, takes care of.
10th of March
My lord.
for hearing.
Yes, much.
May I please? Sir, the matter relates to no confidence motion, my lord, against the petitioner, who is the chairman of my lord, Dargaon Municipal Board, my lord.
Oh.
My lord, today, my lord, I have received a copy of a affidavit filed by respondent number 16, my lord. I pray that lordship may take up this matter on 10th of February, my lord.
10th February.
My lord.
Not 10th. Let it be 11th.
My lord, 11th, sir, my lord, I have some problem, my lord.
Then take any date.
17,
after.
my lord.
Don't use a Tuesday because let us first understand what is the matter. Does it require to be listed on a Tuesday and a Thursday? It may not require elongated hearing. Then
Then, my lord, on
13th.
6th, 13th.
List on 13th, enabling the counsel for the petitioner to complete his instructions and file reply affidavit
If
to the
required.
affidavit filed by the respondent.
16.
16,
If
if so
required.
advised.
13, my lord.
List on 13.
Nice.
44.
Here, your lordship, pursuant to last directions, they have provided us our liabilities, your lordship. Only thing, your lordship, our account has been, all the accounts has been freezed, your lordship, including cash credit account, your lordship. Ultimately, even if we wish to pay, your lordship, we cannot pay, your lordship. That's the problem.
Who's for the respondent?
D. Chaudhary appears for the.
Where is that state council not available on this?
We are, your lordship, facing serious trouble, your lordship, due to freezing of the accounts, your lordship. And while freezing, they have not followed the procedure also, your lordship. We just want for defreezing and then, your lordship, of
You
the
give an
account.
undertaking before the authorities to
Yeah.
say that you want to pay this amount.
Yes, Your Lordship, we want to pay the amount, Your Lordship. Only thing, Your Lordship, we want to pay it in some installment, Your Lordship.
That is where.
That's Your Lordship's order is also there, Your Lordship, which
What is the amount required to be paid?
Your Lordship, it will be around. As per the demand notice, Your Lordship, 31 lakhs. Not Your
And
Lordship.
how many installments you want?
Lordship,
How many installments you want?
5 installment, Your Lordship.
5 installments.
That's my prayer, Your Lordship may consider it.
Interest-free installments.
Lordship.
Interest-free installments. You pay interest.
No, Your Lordship, interest is included, Your Lordship. in the
No, but even for the installments, you have to pay interest for the
Lordship-
delayed amount.
Lordship, that Your Lordship, if that will have to pay, Your Lordship, if we required to be paid, Your Lordship, that is not the issue, Your Lordship. In fact, what has happened with us,
So
Your
this is what the banks normally do.
Lordship,
Therefore, I was just
Lordship.
asking, but in the absence of the state council, what
Lordship.
is to be done?
Otherwise, Your Lordship may kindly see the last order, Your
No,
Lordship.
we would have disposed it off,
Lordship.
subject to the state council agreeing that. Or you,
He is coming, Your Lordship.
he wants to make a payment in installments, but you have frozen his account.
Lordship may take it up next week. In the meantime, I will have that instruction with regard to the EMI and how the account can be defreezed, Lordship.
Mr. S. Bhattapur, counsel for the petitioner, submits that the department has given the particulars of the tax due,
Lordship.
tax amount,
Lordship.
liability due
Lordship.
in respect of GST.
Lordship.
Stop. He, however, expresses difficulty in view of the fact that his bank account has been freezed by the respondent
Lordship.
authorities. And further, he seeks liberty of the court to make this payment on some installments.
Lordship.
Mr. B. Chaudhary, Learned Standing Counsel, submits that he will obtain his instructions in the matter and apprise the court on
Lordship, next week.
4th
Lordship, 4th, Your Lordship.
4th February.
Deeply obliged.
May it please your Lordship. Lordship, in this matter, Lordship, the issue was whether place and venue.
Venue.
Yes, Lordship.
Lordship, the senior resort will be appearing through VC, Lordship.
Lord, am I audible to your Lordship?
Yes, you are audible. But let us have it on 12th of February. Subject to convenience.
All right, my lord. All right, 12th of February.
12th of February, so that we can, it will require some amount of hearing, perhaps.
Yes. And your Lordship, on the last date, your Lordship directed us to give the citations with the paragraph numbers that we have provided to the bench assistant.
Okay, okay.
On 12th, your Lordship, we can have it.
Okay, okay. All right, list this matter on 12th, as agreed to by the counsel for the parties. Attempt will be made to dispose of this petition on the next date fixed.
Much obliged.
Just accordingly. Citation dice given. Silo.
Lordship,
Lordship, I will be providing. I have got the printouts actually. I will be providing the
We don't need
citations.
printout. You just give
Lordship.
the citations, send it by email. That's better, in fact, so that we can
Lordship.
retrieve it as and when we want it. Both parties.
Actually, two judgments are already there, Lordship, in the court.
All right,
That's why.
all right. Whatever is there is there.
List.
You don't have to take the trouble to take printouts. Printouts will have it.
All right, Lordship.
Give us the citation, case numbers and paragraph numbers. That's all.
Lordship.
And send it by email.